Justice Watchers, before we begin, I want to make this absolutely clear. The following broadcast contains public domain courtroom footage, commentary, and legal analysis. This content is presented under the Fair Use Doctrine as defined by 17 U.S.C. 107 and is protected by multiple Supreme Court rulings, which you see below. This stream is transformative, educational, and journalistic in nature. It includes original commentary, trial breakdowns, legal interpretation, and critical analysis, not raw redistribution. We do not claim ownership over any public domain footage, and all use is strictly within legal bounds. If you're watching this content, you're engaging in a protected, transformative experience, grounded in law, never in speculation. And if anyone has a problem with that, take it up with Campbell, Brady, Miranda, and Irvin. Remember, guys, justice always works better when we watch. So keep watching. See you in the courtroom.
We stand tall for truth, you see. No chains of doubt, we're running free. Equality, we shout out loud. With justice here, we're feeling proud. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all. From the streets to the court we fight. In the dark we bring the light. Tear down walls that hold us back. With unity we stay on track. Justice is a process, watch us rise. We ignite the change, open eyes. Together strong, we'll never fall. Justice is a right for all.
Some kind of because that's not how it came.
See, I almost want my purple jeans. Oh, I did. Yeah.
Let me start doing it.
Subscription.
Because it did sound like no.
Every month. I mean, as much as you're informed, that's a great idea. You work take now.
How about turn this off?
Start off.
I want to try to do it.
I think if you're either a DA or a public defender, they should give you a line item. You would, right? For files. Yeah.
That is like, so today, this is what it's like. How do I just go back to regular?
I'm sorry?
I just go back to my regular.
It should be.
She sent the note.
No, she sent a new link. I can forward it to you if you'd like. They have the right to defer.
Hopefully, they have 512.
Yeah, that's where.
And they can split it.
Either way. They can do half. They
Yeah,
can do
yeah, right.
one and that.
Yeah.
Sometimes if they got two or they do something, they both get a chance to do.
Yeah.
First one will be going, second one will be going.
Yeah. I'm just thinking is, but conceivably I could just end up going first, right?
They may tell you.
Been a long time. What we got?
Who's going first?
You're,
I mean, Mitch.
How do I get it back to my work? Take it off of YouTube, get it back just to my work.
yeah, it's not on.
Yeah.
Earlier today, it was clear today, though. All right, so where are the sound? Right here, here's on speaker. How do I change the output?
No, it should be right. It's real time.
Can I see your computer's not on?
Yeah, you can sure use mine. If you need to. I don't know if it's better, but
So you're right. Failure to give a jury charge is subject
I
to
think I
plain
should.
error analysis.
I share this.
Everybody's trying theirs.
okay.
I think what I was thinking of is you do object during conference, but don't object when the charge is actually given.
Becomes later.
Yeah. I see, yeah. I thought they said it was waived.
It is waived. You know, that's why. Yeah.
So I see.
It's not forfeited. It's waived. You got it. Waived without.
That's right.
There's something
Can you play it through Zoom?
that's the. Oh, um, oh, charge.
Yeah, I'll go to. Okay. Sure.
Mhm.
Yeah, PD player.
You know, it's already got this happening and all. So, when I'm at the jury, you know, she didn't smoke, you know, no drugs, nothing like that. And then she had her own sister got to smoking, and like I wouldn't know this time I smoked. So. Then, you know, just time went on, and you know, she.
This is what it's happening.
So it's clear. So that's what you gotta do.
I'm not gonna play it. I'll play the original one. And he said the rest of them. Well, this is the one he's doing.
Within the power of distribute cell phones, vibrate a style and simple. Front rows on person use the system.
Thanks for the money.
Okay, do we have Mr. Wolfenbarger dressed out? We just need to have him brought out. Is Mr. Wolfenbarger dressed out?
Yes, he's just out. I'm ready.
Thank you.
Yes, ma'am. Oh, you're.
You dropped something.
Are you able to turn it up? I have a soundboard right here. Are you able to turn it up? Oh. That's why I was asking. Yes. Let me get the correct one.
Your Honor.
Hang on just one second.
Yeah.
Madam Clerk, are you ready? Okay, we're going to go on the record. And today is the 20th of August in the trial of the state of Georgia versus Christopher Wolfenbarger, case number 24SC004-201. I'll note for the record that Mr. Wolfenbarger is present here in the courtroom along with his counsel, and that counsel for the state is also present. Mr. Samuel.
When I left court yesterday, I think the prosecutors are still in here. I was walking past, towards the elevator, and one of the jurors was in the sitting area.
Yes, sir.
And he looked like he was, like really, really ill. He was just kind of hunched over, and I have no medical training. Plus, I was debating my role as a good Samaritan and my job as a lawyer. Fortunately, I saw there was a deputy at the end of the hall.
Yes.
And I went to the deputy and I said, someone's got to do, I can't talk to this person. So the deputy went back and talked with him. I was not within hearing distance and stayed out of sight. I gather he was in a great deal of pain from a back injury and was taking medication. I'm not quite sure what happened after that. I mean, the deputy eventually left, and there was nothing for me to do. I wasn't going to sit there with the juror, obviously. I just bring it to your attention that the juror was apparently in so much pain he was taking medication. That concerns me if he's sitting here in the courtroom.
Well, thank you. Do you know which juror it was by number?
Certainly not by number. It was a black man, not the one who does dialysis.
So not 43.
And not the taller man who, I'm sorry, I don't.
Okay. I mean, the main reason I ask is that I'm surprised that you would have such an encounter and that juror or other jurors would not have communicated to my staff, hey, I'm having an issue. And I've not heard any such communication from that juror. So if they are struggling with that, it's unfortunate, but it seems as if they don't feel the need to bring it to my attention.
I just felt the need for me to bring it to your attention, but
I understand.
I remember, obviously I see the jury. I've never seen him in the jury box appear under any distress. So
okay. Well, what I'll do for now, rather than, formally inquire or put anybody on the spot, is just, if it's okay with y'all, is just have Miss Johnson check in. She's my JA who takes care of the jurors, and make sure everybody's comfortable. And if you're not comfortable, you're having issues paying attention, you need to let me know so I can bring it to the judge's attention and let you know if I get any report from that. Okay.
I'll just make a mental note of where he's sitting.
And then maybe you can tell me, we can identify him further so we'll at least know which juror it is. Okay.
I think you're right. I think because Mr. McDermott brought that to my attention. Mm-hmm. And as I was going out of the courtroom, I saw that juror. I believe it's a juror who may work for Delta, if I'm not mistaken, the shorter black man. I think yesterday he was sitting in the second
or third from the end.
On the back row. I think he had on green yesterday. And I saw him leaving as I was going towards the right, towards the restroom. It looked like he was getting up from that area and leaving the courthouse.
Hang on just 1 second.
He did mention back work on disability.
Yes. Are we ready to get started? Wait, Miss Hilton, you said you wanted to check the audio. Yes, please. Will you hit play for just a moment?
let me get some personal
Is that interference something that you've experienced before, or is it something to do with your broadcasting it?
I think it might be the broadcasting. I think it might be the broadcasting. Earlier today, it was as clear as day. I could hear every word, so I'm not sure.
Have you attempted to do it on your
Bluetooth?
On your speaker instead of through the court's audio system, which is not great, to say the least?
Terry was here yesterday when we concluded. She is currently on the stand in Gwinnett. She took the stand at 11:30 and is on now, so we're waiting for her to get out. But that would be one of our last witnesses. I think we're at 3 remaining.
Forgive me, Dr. Terry is the ME?
Yes,
okay.
Device not found. Ready to air.
Alright.
Connected to PHEPL 5400039F10.
Now it's connected.
Up until, later on, there's a couple months before you got a fight, and she had to work in his fault life up there on Norville. And she had a guy that cook that was there.
I think we're ready. Okay. So are we ready for the jury? Yes. Ms. Hilton?
Yes.
Mr. McDermott?
Yes, ma'am.
Okay. Can we have the jury, please? Be seated. Good afternoon, ladies and gentlemen. We are ready to go ahead and get started for the afternoon session. Thank you all. Ms. Hilton, the state may call its next witness.
Thank you, Your Honor. The state calls Mike Sprinkle to the stand.
Come on up, sir. When you reach the witness stand, before you have a seat, if you'll turn and face the deputy and raise your right hand, he'll swear you in.
Swear our heart has the testimony that shall not give the truth, the whole truth, and nothing but the truth, sir. I am Please state the security full name for the court.
First name Michael, Michael. Last name Sprinkle, Sprinkel.
And good afternoon, Mr. Sprinkle. How are you currently employed?
I am employed as a Deputy District Attorney at the office of the Fulton County District Attorney here in Atlanta, Georgia.
And how long have you been with the District Attorney's office?
Since June of 2011, so about 14 years.
And what unit do you work in?
I am in the unindicted homicide unit.
And what are your job duties and responsibilities as a deputy in the unindicted homicide unit?
I oversee the unit, the unindicted homicide unit, which screens the incoming homicide cases that come from the various jurisdictions in Fulton County, and I screen them specifically prior to their presentation to the Fulton County Grand Jury.
And in that role, have you at times worked on cold cases?
I have.
And within those files, have you had to enhance audio or video recordings to assist with your investigation or looking into that case?
Yes.
I want to direct your attention to the Melissa Wolfenbarger case. Did you have any occasion to work on that case?
I did.
And within that, did you have the occasion to enhance a September 12, 2001 Henry County interview video?
Yes. Well, yes. It was on I obtained the original video. It was on a video cassette, like a VHS cassette. I had a VCR in my office. And I also had this little USB device that had an RCA connection on it. So essentially it made it so I could hook the VCR up using RCA cables to my computer and then record it. And in doing that, I extracted the audio specifically off the VHS cassette. And I don't recall what exactly I did. I just know that I created an audio file that I could hear better than when I watched the video cassette originally.
Okay. And was that able to help enhance you listening to the audio that was on that video cassette?
Yes.
Okay. And have you had the opportunity to review that audio that you extracted in preparation for your testimony today?
Yes, there was a disc, an optical disc that was handed to me outside the courtroom. There were 2 files on it. And I listened to them, and they were the audio files. There were 2 of them. One was an excerpt from the audio file that I created, and the other was the full audio file that I created.
All right. Yeah, permission to approach?
Excuse me?
Permission to approach.
Go, yes.
I'm going to show you what's in market states in 73A. Do you recognize 73A?
Yes, this is the disc that I just described.
And did both the original audio and appear to be the full audio that you extracted from this September 12, 2001 video?
Yes, it hadn't been altered or manipulated in any way.
Okay. And then was there a redacted version on there as well?
The redacted version was on there. That was the excerpt of the original, yes.
Your Honor, at this time, the state would like to admit 73A into evidence.
Mr. McDermott?
No objection.
73A is admitted.
Permission to publish.
Permission granted. Ladies and gentlemen, I'll just remind you, as I have when we've played audio for you, there may be things that have been removed from the audio. You may perceive that, and I'll just remind you that the fact that redactions have been made is not something that you should consider, and why or what might have been said or why the court caused it to be redacted is not something that you should speculate about. Thank you all.
they're all worried about, you know, whether I put on
Your Honor, may I object?
Yes, sure. You pause that, please. to ask you to step out of the room for just a few minutes. Thank you for your patience.
All right, jury.
Just let the jury get clear and then we can. Clear. Mr. Sprinkle, I'm going to ask you to step off and step back outside, please.
Yes, Your Honor.
Thank you. Okay. So just to make a record, the nature of Mr. McDermott's objection was that what was being played for the jury for, I'd say, somewhere between maybe 30 seconds to a minute really wasn't audible, right? It just sounds like Charlie Brown's parents, right? Mom, 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 mom. You know, we can tell somebody's talking, but you can't really tell what they're saying. I don't know if the fact that that speaker was facing the jury made it more audible and understandable to them, but I didn't get the impression that anybody really understood what was being said. Mr. McDermott's objection was that it was audible at some point, and if it's audible, it ought to be audible in the courtroom or it ought not to be played. We discussed some variations of how we might address this issue, and ultimately, I decided to take a break because I think I understand Ms. Hilton's representation to be that at various times she has listened to that recording and that it is in its, I guess, the point of Mr. Sprinkle's actions of enhancing the audio was to make the entire thing audible, understandable. And if that's the case in some media, then y'all need to take a minute to figure out how to make it audible in this courtroom. And if it can't be made to be audible in the courtroom, then I'm not exactly sure how it's admissible if it's not, if we can't understand anything being said. The fact that he gave a statement is already in evidence on that date. So.
You know, after her parents locked me up like eight, 9 times, you know, you're still a fish bag, like, you know, so I don't have a good relationship with them at all. Kind of curious about that part of the movie, where I talk to them. But, I mean, she said, all everything was real, we had a real good marriage for a while. And she got in a system. I know we was living, I don't know where exactly we lived. We've been living in Atlanta.
Can you all understand that?
That was this was working at Walmart. And, like, it just,
I mean, I can understand it better than I could before, to the extent that audio quality is always an issue.
Best part to the middle.
And you can really do, you know, call your mom or your sister or somebody, you know. And if you get the thing.
That's 10 minutes
I guess you music. I don't know, so about the same kind of day, but I don't really. So we use the direction. She's there, I mean, she's probably around that same area, but I don't.
That's 16 minutes out.
It's got to move. Which I don't know. But I mean, these people are all they hate me.
That's 20 minutes out.
They all interested.
If it's the same quality all the way
Anybody,
through,
anything I'm telling you right now, you
and the judge thinks that's all.
Anybody that's around here, they'll tell you.
That's about 25 minutes
I mean,
out.
there ain't no way I want to work.
Okay.
Now, I just want to start at the beginning just to see how far it went.
Thank you.
Right here next to the pretty army base, they're all worried about, computer games. After I come on, they get home. Go back. Starting out that, I was about all these over okay, mine, it shows my house just door at home.
So it's probably about 1:20 where it gets clearer, about 1 minute and 20 seconds. And the intro is him, what I can hear here is him just getting his name, where he lived, and that's the first minute.
I read her through broken lines. It shows my house just door at home.
Okay.
That's the first time I.
So we would propose starting at about 1:30, 1 minute and 30.
Is there any, forgive me if that's what you've just said, Ms. Hilton, but is there any understanding about what it is that was being said before that no one can understand? Do we not know?
So I can hear what he's saying. What he's asking is his contact information in the first minute. He's asking him to give me a little bit of background of their history. The detective asks him to go back over your history, and then he starts.
I met her through broken lines. She shows my house just door at home.
Okay. And that's kind of where this is really where he starts talking about their history.
Okay.
And we're at 1 minute and 45 minutes.
Okay. So what is the time designation on that tape that you're going to start playing?
I'm going to start it at 1:40 or 1:35 to the end.
Mr. McDermott?
I'm still not happy with the quality of it overall. I think asking the jury to sit through 20 to 30 minutes of that is going to be, its own form of torture. And I don't necessarily see the probative value of it because so little bit of it's audible, you can pick up bits and pieces. That's not a fair copy of an interview, I don't think. It's certainly not anything that would get close to a rule of completeness. So I would still object to playing it at all. If the court has determined that that's audible enough for the jury, obviously that's your call. But I maintain the objection not to play it at all.
Okay.
And furthermore, we've heard testimony from Detective Stott, who kept fairly detailed notes about this interview, and he gave us a pretty thorough rundown of everything that was said in it. So I'm not sure what's going to be picked up from listening to this tin can version of it.
Ms. Hilton?
Yes, Your Honor. If Mr. Stott couldn't remember certain things that I asked him as far as dates, I asked him specifically about some dates, specific things that Mr. Wolfenbarger said about relationships, that he had with the Patton family, and there were just things he did not remember. And I believe I asked him towards the conclusion, does the video contain the entirety of your statement? Would that be the fairest representation of your interview with Mr. Wolfenbarger? And he said yes, because everything that I asked him, he did not remember the full contents of this audio, of this video interview from 2001. And we do think it's relevant to play the video was in. What we're now doing is trying to make sure that the jurors can hear the audio from that video, so that if they wanted to play the video, they could play it in the back, but here is the audio that goes along with this video. And the redactions are redactions in which we advised the defense that we were taking out certain portions. The portions that are redacted from the video is Mr. Wolfenbarger's criminal history. Those are the things that are out, but everything else is what Mr. McDermott agreed should be in. Matter of fact, he asked for us to add something in that we had taken out that referenced Mr. Wolfenbarger's criminal history. So we believe that this is a depiction so that the jurors can hear fully what Mr. Wolfenbarger said in 2001.
I guess my final point would be that, well, yeah, I did agree to some redactions. Those are not the issue as we were talking about here. My final point would be this. We're playing something for a jury that we're all sitting here listening to, and we can pick up bits and pieces. Some of it we can hear, some of it we can't. Some of the stuff in that interview I consider exculpatory and good for the defense. Other things I'm sure the state considers good for their case. We have no idea what the jury is going to be able to hear or not hear out of any of that. And it's just not, you're taking a crapshoot. And I don't want that going before the jury. If we have a clear version of that, then I wouldn't object to it. But there's just no way of telling what anyone's going to pick up from that. And that's not a fair thing to put before the jury.
And I think that goes to weight, not admissibility, Your Honor. They can argue that it's not clear. They can argue whatever. They can blame the state for the bad audio. They can do all of those things. But we can put this speaker up there and they can hear whatever it is that they determine that they can hear, and the defense can do with it as they wish.
I mean, you're not wrong, Ms. Hilton, in terms of the defense can use it against you if they choose to, right? And make the arguments that Mr. McDermott wants to make. I will say that I think the thing I'm frustrated by, and I blame it on the court technology, not on the state, but the thing I'm frustrated by is if you can play it at your computer and hear it, right, and not in this weird garbled state that it is now, why can't we? That's what I'm frustrated by.
But I think as I played it a few seconds ago, we were all able to hear it. I mean, I don't know how this both of
Is that what the audio sounds like when you play it for yourself at your computer or whatever?
Yeah, I mean, yes, I can hear the words.
Except that you're telling me that, like, you're telling me things that are being said at the beginning of the video that I can't hear. And that's what I don't understand. And it's not that I can't hear it, it's that I can't make out anything, and I don't understand why you can if the court can't. And is it an audio quality issue because you're listening to it, you know, on your computer or whatever?
I'm not sure, Your Honor. I mean, I can maybe bring it up closer, bring this speaker up closer to the court so you can hear it, what I hear, but I can hear it. I can hear him, and maybe because I've listened to it, I know what's happening, and that could possibly be the case. But as we've moved the speaker down, and I kept asking and starting at different points, I think everyone heard everything. That wasn't hard to hear. It was the first minute and 30 seconds. But I believe that everything after that, when I stopped it at the various points a few seconds ago, I believe everyone heard, or at least no one communicated that they did not hear what was being projected on the audio.
Okay. Mr. McDermott, your objection is going to be overruled. I'm going to let the state play the audio for whatever it's worth. Okay?
I'll just note for the record that Ms. Hilton stated just a minute ago that she would be willing to put the speaker up closer to the jury, quote, so they can hear whatever they can hear. And that's my argument.
Right, but that's always, I mean, that's the problem with the quality of videos. Sometimes the ones that were done 3 days ago in a police interview room that's outfitted with appropriate audio, whatever's there is whatever's there, and whatever the jury hears is what the jury hears based on what's there, and that's just a sad fact of life. So your objection is noted for the record. It's overruled. And you're going to start it at the 135 mark? Okay, if you'll go ahead and cue that up at the 135 mark.
It's ready.
Okay, so all you have to do is hit play?
Yep.
Okay. So can we have our jury back, Deputy? Thank you. Oh, can we have our witness back too? I'm sorry. Thank you, sir. Mr. Sprinkle, you can go ahead and be seated. Sorry for that delay, ladies and gentlemen. Thank you. Ms. Ms. Hilton, you may proceed.
Thank you, Your Honor.
I never to a girlfriend of mine. She showed me my house, this school, and it wasn't half. That's the first time I've seen her. She showed it off like that. She, stories about the other parents. They get along. What matter, we went away together and come back and get your about all that. It's about 95, we got married. After parents fought me up like 8, 9 times, we threw my foot race, like people over there do. So I don't have a good relationship with them at all. I'm kind of scared about that's why we go back and we'll talk to them. But, took it off. Yeah, really nice for this first a while. I was living, I don't know where that was living. We didn't live in the line. That was just a 50 was in the wall. Like it just, I don't know. She had left it, red dot. Okay, moving on. Okay. Her sister kept telling how bad she had a lady and how how bad it's not. She kept putting thoughts of this in her head, like maybe you will, all the other happening and all. Well, I didn't really know shit mode, drugs and like that. And she had her sister got smoked in. Like I wouldn't know this kind of thing. Then, just time went on, and she just pulled. Later on, there's a couple months closer, got the light, and she went to work in this waffle house up in Yorkville. And she knows the guy that took over there. Well, I guess they got screwed and whatever or not. She come on, she put him out the door or walk out, but he worked there. She decided to do him, and she stayed long for 3 or 4 days at a time, but come back, we had a restoration. Then, she just come back one day and she would give it down on her. All this happened about the same time. This was right around Thanksgiving, I remember that. And I was thinking it was 99, but she's going to bed at 98. Anyway, I'm going to say, 98. She come back. She doesn't want she would come back good with me, but she stayed with me like a week. I guess that was just to get her stuff. And then she stayed there. She left again. Come back a couple days later. She come back and we had a long talk that night. The next morning I woke up. She didn't got our stuff. Left. A buddy of mine had been on a water train with big 2 kids. I had strollers for her. He got off the 5 points for me. She kept one over. You got to have 2 years. We were with your boss last time. So 98, somewhere around Thanksgiving, that's where about 12 weeks, that's how we all got together. That's how we did it for years. I'm telling you, yeah, it's in 99, yeah, just wanted to know, I got everything here. So, where were you living at now? I lived at 1 we lived at 1 First Street. Whenever I'm going now. That time I was with 8.3. The first one she worked with, and I really don't know how she, to this day, I don't know why she went, really, like, them in the downtown line. She got on water train, went all the way up to Dorothy. And the only reason she gave me minutes at that time was, because it was right off the water train. I mean, there's a bunch of them there. I mean, to this day, I'm thinking, that's one thing her and her sister knows, she never let me on her that, so. I don't know if it was guys she knew from before or what, I'm not that. If you say we use it, I would. So they really would be sporadically, yeah. I'll say it's almost, I won't say 3 weeks. Because it was right around, it was almost Christmas, I reckon. Then after she left, I didn't hear too much from her for, a couple months, or whatever. Back in, April, the following year, which I guess would be 9, I think. And I was coming down this street, almost, about a line like that. But right where the train station is, and I was coming out through there, and she was walking in the road, and this is just in a white girl, blowing the horn, just, over 90 degrees around there, But, I stopped my, and I blew the horn at her, and I got the road about 50, 70 times on that time. I knew it was. I couldn't believe it. I don't know, I guess my sister could tell you how she looked. You got to picture how she looked when she was right. Yeah, that was before. That was like the last year after we got married. After that, she cut all her hair short, dyed it red. Started smoking, and then she was over it. When I said to her, she walked away from me, I couldn't believe it, looked for my heart. We stopped, and she said she wanted to talk, so we went to Taco Bell, we were over or whatever, And at the time, she was like, no, I made a mistake, I'm going to come back home. I was like, you don't need to be emotional, so whatever it's going to take to me, and just like this, and it's better off. I just move on, It looked like she like tracked and stuff from home with it. Yeah, I don't really key up on all that, Look at all this. She looked awful. She was telling me what was going on and all this. Basically, what had happened was, from the conversation I had with her that time, she got to hear this guy, right? And you see what she kept putting thoughts in her head. Like, all these people were living in one house, like 5 or 6 of them in one house. And, just the party locked out, or go out and party and the party all the time. And she was like, she felt like she was missing out on all that. Didn't she? That was what she wanted to do, and she that wasn't right. I told her at that time, I told her I should do that, and she really did, to call your mom or your sister or somebody, How would you, communicate with the kids Never, she wasn't. When you got my mom, she never really, ever, from the time that she found over, she never really called me, they called me nothing. From day one, it's all I did. And she didn't even want to have Joey, she wanted to have him aborted. I wouldn't do that. She was at our Christmas trouble whenever you saw her. She was on the way there. She was still hanging out with that group. She was part of that. Student, real smart, she's a line smart student, real intelligent that way, but as far as, you know, she was real naive, you know, I don't know that way, you know, but not quite that. She was basically, if you could put an idea in her and you would think about it, she would swear that's right. And that's, I guess that's one of those problems that goes away all the time. But she was a real follower. When we saw it now, we still working with her, and I really didn't want to blow my whole mind, and it was really just hard for me to sit there and talk like that, you know, I was trying to. It's like she was trying to go into all, you know, all of the around that, and I just didn't, you know what I mean? I didn't want to know no more than I had to know. I just didn't. But there's no way I believe that she ain't calling on. That's the old reason I ain't. Or anything like that. She just didn't think that much was a kid. She didn't know what she did talk to you. That's why I'm going to say that she called. But I've never seen it. I've seen her call mom once or twice. I mean, I never see it like that. I seen her. She said she used to send her mom calls and all the time. I wasn't doubt her. I don't really know. You know what I mean? You know that guy's name? I do not. Only thing I know for one of her certain fact, his name is Mike. I remember that. As far as the last name, I think. That she was messing with. I know the other night she lived in Shackelford Lodge, more there, because that's what I wanted. Whenever her mom would say she was coming back with me, when I went there to pick her up, was at Shackelford Lodge. That was where I went to get her. But she said those people, you know, they had an argument, she was having an argument with this guy or whatever, I guess. That's where she just, when she went with him, that's where she was trying. She was all up around that area. I mean, we never knew anybody in that area, you know? What would she be doing now? I can't find anywhere. I can't find where anywhere. You know, for looking on Social Security, taxes, whatever. Well, the only thing that I know that she would, like I say, we've been here, that's all I can think of. I really don't know. It's just my opinion. It's just she went through, because to this day, she's still ready with me. I'm just now, you know, I get more with the voice for her. The only thing I can figure she might have done went through changing that, but she never had to do that. And the only thing I can see is that she changed it when she got married. And she changed everything. It's never real easy to want to do it. If you have probation, you don't probation. Yeah, that, and I all kind of heard through metal with it once and said they want to vote for that. Or I guess you just look at the court for a few things, or some kind of. There was another detective inside you that was looking for. There's a man and a woman from the court. Okay. Looking for, they're not the same kind of page, I don't know. How we use the direction. She's there, I mean, she's probably around that same area, but I don't have no way to get in touch. Anybody that, and we didn't have to be friends or anything, but we don't. You know, we associated with a whole lot of people. Is anybody else, any other family member, I don't know, She would talk to, this is something she used to talk to my old sister. And that was, you know, because we didn't really know anybody. We lived with her, and she liked everybody, you know, we had no friends around there. And, you know, we go like get married or something like that, you know, she had all this history. It's my understanding, and I have never seen this, my old sister, my mom told me that she wrote my sister a note. Was they to have this note or whatever, you know, they're taking it, but I didn't get it to you. But my sister told me that she wrote a note explaining all of what was going on. And this apparently is after she left me. So, I don't have too much of it. Where she said, I don't even know if it's Canberra and married. I mean, and when Pat was and come over and talk about this, you know, you can ask my sister, you can ask my mom, I thought, I want to listen to her around me. I want to take me to the under and she feels like, if you can answer, I don't even get, anytime I get to you know, it's just hard. The only time I really have a kid come stay with me is when I feel very busy with students, they come stay with me for a week, and that's okay. That's, you know, I don't know if I want to you got to that's really hard. You got to approach her, that's the way you do approach her. Take care of you. Everything you know about it, everything. But yeah, you can learn private school, you know, everything. I mean, I don't know. And I mean, I would have called her mom. You know, and talk to them, but every single time we passed, I've ever seen these people, and then we locked up like 8 times. Her husband had stopped and beat the crap out of me, and I was on the parking lot. I said, that's the last time I ever seen, you know, and I'm like, I'm trying to go over there, you know, so, you know, but I swear, after you stop coming by there, because every time you think you come out of home, you know, I call the car, over there, and because one time, we were on, I called her to start with you, but she went out. I kind of got the impression, you know, that this girl had gone on, she wasn't involved with y'all, and my mother, y'all get involved with it, you know, like, that was all done, y'all, and we got to understand that, but at the same time, I kind of wonder what's going on with it, I swear, I believe she got in touch with her mom. Her mom was making it out like she had a real good relationship with her. She did. They really did. They didn't ever. I mean, I guess she was trying to build a relationship with her sister. I felt like she would have gotten to her sister a million times before she got to her mom. I mean, the last time I knew where her sister was, she was living in Pizza. And I think, and it's my understanding that I don't know for a fact, but it's my understanding that her sister moved. But I don't know now. But I mean, these people are always hating me. Her sister, all. And her sister, you can look, you know, anyway, but her sister, you know, always been on that track. And I hope, you know, she's not on anything better. Because her sister went through one time, and finally was their car, and told all their family that I come over there and got their car one night, and then come up later on that the night one, I just come and told them that we had the car. I know it's been hard to believe, man, but really not. I mean, the thing that's happened to her is that she either, I don't know if it's suicide or something, somebody who's hanging with it, I don't think she committed suicide. This girl was really strong. That's one thing I can say about her. She was really, she had the, and I don't know what word I'm looking for, she had the endurance, you know what I mean? Just, with her sister, when she was coming up, her sister, like, had a baby in the bathroom, and didn't tell nobody about it. She took the baby in the fall. And Melissa found it like 3 days later in the gym bag. You know, that was much more strange. You know, pretty good. You know, she was Wolfenbarger, that best friend. You know, and there's nothing ever to be done about it. She got a real strong mentality. I don't feel, you know, I'm not being wrong with her, but I don't think. I'm sorry, we were able to, she can't be mad at all these people. I don't, you know what I mean? I don't even know if she got any of these people. Not that something bad with you and her husband, it's bad. There's something bad with me. But I swear, I don't know how. I really don't know if her sister put her in the up there, or how she got in the door there, and how, period. You know, we didn't know it was like this. And later on, I mean, a buddy of mine had moved up that way, that was, no, it didn't have anything to do with her. One name which is, probably a copy of what she tried to make, because, I mean, the simple reason the way we get you with what kind of name. Because she can be anything. And she knows that she got the real one, she got, she can do it. I thought all of it. I mean, it's like, I think things would be a lot different if we were there. A lot of people, you know, if we stayed in like Flint River, a little town, you know, we went to where everybody did something, and many times we moved up to life and never back. Your relationship, you know, with Miss Patton, did y'all go on, and she, how was it faithful to y'all? I mean, how she talked to you, man, you feel like, you know, I mean, I come up, you know, this is the first time I ever really talked to that woman like that. Ever really, she always, it didn't hate me. It really did. She cannot stand me with everything. You know what I mean? And I all, you know, living, right we got married, I will, you know, I called up and tell them about that, because at that time she was telling me all everything, what, you know, happened and everything. I mean, today was the first day that I really, you know, we really talked, you know, and it just blew me away that today is not talking to her at all. I guess that's mom, because I was there in shock. I'm like, there's no way. I mean, I used to work with her dad when we first got married, and I used to walk with her, and I'm like, what? These people are real bad time. That's one thing I said about them. They did, I don't remember anything, the insurance fraud, stuff like that. They ever come out and accuse you, say they think you did something to her, or, you know, something like that? I haven't talked. I try to stop. I try to avoid these people like play. If any kind of interaction I've ever had around these people, it got me beat up, I put them in jail. And for me, I mean, it's kind of a strange thing when we know how we even got married, because it's like, in my mind, it's just like a goal, and it's like, I ain't married this girl, you know, I'm still with people, and they don't. You know what I mean? It's just, right? Well, I don't know, I mean, it kind of looks like for a while there, you could have done something about it or whatever, you know, because you want to use the locate and get the story from the package, you know, all those things, get the carefully, that's like you said. You can ask me, you can go to anybody, anything I'm telling you right now, you can ask anyone, like I mean, anybody that's around there, and they'll tell you the same. I mean, there ain't no way I want to work on you. So yeah, we live in the other one parking lot in the front group. So in the fourth parking lot, you know, she could all. When did you find out that she was reported missing? Or like that fourth down, just feel like I think, no, I think the very first time you come out of it, I think you spoke down, I don't remember, is that correct? I think you spoke on along like that. Showing you like that. About a whole year. I mean, that guy tell you right there that she didn't have a relationship with her mama, and her mama saying she did. If her mama waited the whole year, you know what I mean? There's no way. So that, that's where it came out of. Again, it just looked like a situation where you got somebody that goes off and does whatever they do, maybe a drug addict or something that has, maybe they're going to do things. But I thought, it seemed odd after a year, you have to kind of make it up like you did, you call it more right out, you go to it. But, still, it seems like somebody, like this, or something bad that happened to them, I don't know. And I mean, that might have been all the, I've been sitting here, and you don't know how long I've been sitting here just going over scenario after scenario, trying to figure it out what it is, especially now, man, that's what it is now. After you told her mom, and she didn't tell her mom. But the only thing which I was sitting there all eager with, is we did this thing, we changed the name and everything, was the only thing I kept saying is at the time that we had to set up, we was making money and things, all that, and really not, and proud of that. But he was like, you got to cut off everybody you know that we're going to be wrong. I kept kind of saying that. If indeed that's happening. And that you put that, she just don't have him. And all that, she knows that she's a big part of that way, she wasn't able to decide on other that way, she could go to that, but she had to kind of cut down everybody. Well, the last time that you saw her, she left for Christmas, so we saw her 3 months later, talking about February, March, and all of that, the next year. We're in bad condition. You can have one look in the light. From that picture right there, and I bet, I'm gonna look her, and I think there's a picture of my grandma. Last time she was with my grandma, she had short, cut her hair off short, and bright red. And she did that for the time that she got back in the I thought, they were saying, I mean, she had taken, she had dyed her hair several months before, but then right there towards the end, and especially when I see her in April, her hair was real short, real bright. It was like, they look odd, they look. She stood definitely stood out. I mean, she don't do nothing like that. Not like that. I don't see it, man. And earlier all this time, I swear I thought she was at least in that consistent. That's the only reason I never really pursued it harder. But simply, whether I have a letter, it's just one picture, one child. But at that time, I haven't even kind of good relationship. All this happened. You don't come in with enemy or something that is always nothing what to do. I think it's something like that. This is right now. I live in the other part. We can design the game and do things and all that. That's really very much. All right.
We stopped at 3035, Laura.
Thank you.
No further questions.
Mr. McDermott, do you have questions for this witness?
No questions for this witness.
Thank you, Mr. Sprinkle. You may step down. Ms. Hilton, the state may call its next witness.
Thank you, Your Honor. The state calls Rosa James.
All right, quick 2-second bench.
Sure.
Witness stand, ma'am, and when you get there, if you will, before you have a seat, turn around and face the deputy and raise your right hand. He'll swear you in.
Do you swear to affirm to the testimony that you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Let me have a seat. Please state and spell your full name.
Rosa, Rosa, James, James.
Did you already do the instruction order?
My understanding was after you had qualified
Oh, okay.
or attempted to qualify her.
Thank you.
Thank you.
Good afternoon, Ms. James.
Good afternoon.
How are you employed?
I'm currently employed, well, self-employed at my consulting company called Sania's Place, LLC. I was going to spell it. SANIYAH Place, LLC.
And if you can tell the juror your job duties and responsibilities at your consulting firm.
So my job duties as a consultant is I'm a researcher, practitioner, and also a trainer for intimate partner violence and gender-based violence. I also do sexual violence and child abuse. I do trainings, I do presentations, panels, whatever the community needs me to do, and I also do expert testimonies.
And how long have you had your consulting firm?
It's been open since January of 2023.
And if you can tell the jurors, how long have you been in the space of working in intimate partner violence?
I started working in the intimate partner violence movement in 2012.
Okay. And just tell the jury about your education, your job training in intimate partner violence.
So I started working in the intimate partner violence movement in 2012 at Harbor House of Central Florida. That is a local domestic violence center in Orlando, Florida. And then I continued throughout I continued to the Florida Coalition Against Domestic Violence, and then I moved to the Georgia Coalition Against Domestic Violence, and that's how I got to Georgia. My education background, I have a bachelor's of science and legal studies from the University of Central Florida. I have a master's of social work from the University of Central Florida, which is a clinical program. I also am currently finishing up my PhD at Clark Atlanta University in the social work program, policy and organizational leadership. From the Georgia Coalition Against Domestic Violence, I transitioned to the District Attorney's Office as a domestic violence trainer in July of 2019. And then when Madam DA came into office, I became a senior advocate, senior victim witness advocate, the domestic violence trainer, and domestic violence expert.
And you said you're currently getting your PhD at Clark Atlanta?
Clark Atlanta University.
And are you currently at the dissertation stage?
Yes.
What is your dissertation on?
My dissertation is on intimate partner violence, Black women in service delivery of the local domestic violence centers in Georgia.
Now, you said that you served as a trainer at both the Georgia Coalition Against Domestic Violence and the Florida Coalition Against Domestic Violence. If you could tell the jurors, what type of training have you conducted?
So the foundation of the trainings that I conducted at those two coalitions, they statewide coalitions, is I trained advocates to service survivors of domestic violence. And also these trainings lasted 3 days. On top of that, I had to train the community members as far as healthcare, different systems like healthcare, law enforcement, even in Florida, prosecution offices, any community members throughout the state of Florida and throughout the state of Georgia about domestic violence. I also trained advocates on protective orders. In Florida is injunctions. We train them how to be legal advocates in a sense where they have to help survivors with their injunctions as far as helping them through the court process. And also I've done trainings on the queer community and domestic violence and basically a vast majority of intimate partner violence, child abuse, and how all that relates to gender-based violence.
And over your years of working in the field of intimate partner violence and gender-based violence, have you met with and spoken with victims of intimate partner violence?
Yes, I started in 2012, and that was immediately contact with survivors and through face-to-face trainings, hotline calls, well over 20,000 contacts with survivors of domestic violence.
And I said victim and you said survivors. Tell me, why do you use the term survivors?
So in our world and in the movement, we use survivor because the survivor is a term of endearment. And also some survivors, they use thrivers. They have thrived through the domestic violence. We only typically use victim in this realm, or where I am in the science realm, in the advocacy realm, if someone has fallen due to domestic violence, a casualty.
And you talked about having over 20,000 contacts with survivors of domestic or intimate partner violence. Has those interviews and conversations and interactions assisted you in your understanding of domestic violence relationship dynamics?
Yes.
Now, over your course in working in the field as well, have you met and spoken with offenders or abusers?
Yes.
And can you estimate for the jury about how much contact have you had with offenders or abusers?
So I've had a year of contact with what we would call perpetrators or abusers, because I taught in Florida batterers intervention courses, which is a 32-week-long course that the courts in Florida mandate that if you receive an injunction that you must take.
And have those interactions, those trainings, informed you regarding your understanding of domestic violence and the dynamics of domestic violence?
Yes, it has.
Have you ever testified in the state of Georgia as an expert in domestic violence?
Yes.
How many times?
So Florida has been 27, and I'm about to do the math. I want to say around 47, 48 times in the state of Georgia.
Your Honor, at this time, the state would like to tender Ms. Rosa James as an expert in domestic violence relationships, and domestic violence relationship dynamics.
Mr. Samuel?
We'll reserve word here for cross-examination.
Okay. So, ladies and gentlemen, Mr. Samuel, come here, please. Ms. Hilton, y'all both come here.
Would you like me to step out?
No, you're fine. Thank you. The state is offering, excuse me, I'm sorry. The state is offering the testimony of Ms. James as an expert witness. And so at this moment, I'm going to just instruct you generally that people who testify as experts are testifying because the proponent of the evidence believes that they have specialized experience, training, knowledge in a particular field that's not common knowledge or known to the average citizen. And the law permits a person who is testifying as an expert witness to give their opinions based on that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise, and testimony of an expert like that of all witnesses is to be given only such weight and credit as you think it is properly entitled to receive. Thank you. Please go ahead, Ms. Hilton.
Thank you, Your Honor. Ms. James, can you please define domestic violence for the jury?
Yes, the definition of domestic violence is a pattern of coercive behaviors to gain and maintain control over your partner.
And based on just your training and knowledge, how familiar is the public with the issue of intimate partner and domestic violence?
So the public is familiar with the concept of intimate partner violence, specifically the physical aspect, but the science behind that, the science behind domestic violence, the public typically isn't well versed about what's under the iceberg, typically just above, which is physical violence or any type of sexual violence.
And over the course of the years, has there been some type of increased knowledge with the public as it relates to people watching kind of like true crime television?
Yes, specifically, the boom of the internet is information that's there, and through the true crime or any type of documentary, yes, the public can access that information.
However, in your experience, has the knowledge that comes from, say, internet or from podcasts or true crimes, is that the full knowledge or understanding of the science of domestic violence?
No, it is not.
Based on your work in the field, what are some common misconceptions regarding domestic violence?
So the biggest misconception, if the survivor leaves the relationship, the abuse will stop. And that is not true. The data shows that's the most lethal time in the relationship. That is when the survivor is under the most danger and most likely to be killed. So that is a misconception. The abuse does not stop just because someone leaves the relationship.
And based on kind of some of the trainings that you've done in your experience, what are some of the beliefs about why an individual may remain in an abusive relationship?
So there's a host of concepts and theories and perspectives of why someone would remain in an abusive relationship. The biggest factor is power and control. This person has exerted power and control, and the victim or the survivor feels as if they have to stay and remain in this relationship. Also, there's a component of fear and protection, protection of children, protection of self, protection of family members. It's many different dynamics of domestic violence why someone would remain in that cycle of abuse.
And are there any research, is there any research about how long it usually takes a survivor to leave an abusive relationship?
Yes, the research state on average it takes 7 times to fully leave a relationship that is abusive.
Now, are you familiar with the term or the concept of the cycle of violence?
Yes.
How are you familiar with the cycle of violence?
So the cycle of violence is a cycle that shows how a survivor would remain inside or trapped inside of a abusive relationship with their partner.
And is there a demonstrative that you sometimes use in order to explain the cycle of violence, or is it also called the cycle of abuse?
Yes.
Okay. You have permission to approach?
Go ahead.
I'm going to show you what's been marked as Stacy's exhibit number 79. Do you recognize Stacy's exhibit 79?
Yes.
And how do you recognize Stacy's exhibit number 79?
This is a cycle of abuse. It's an evidence-based tool we use in our practice to show how survivors stay in relationships.
And will this demonstrative assist you in explaining the cycle of abuse to jury?
Yes.
You're at this time to state like the admit Stacy's exhibit 79.
Mr. Samuel?
No objection.
79 is admitted.
Permission to publish.
Permission granted.
Of abuse and explaining the demonstrative that's on the screen.
Yes, so the cycle of abuse, like I stated, is a cycle in which they trapped inside of an abusive relationship. And I know that the public is very familiar with some of these terms, such as like, or even the tension building phase, but I want to explain based on a social theory from 1979 of how we see someone staying inside the relationship with the tension building, right? This is right before the incident.
No physical, economical, it can be humiliation, it could be intimidation, it could be a whole host of things. And it doesn't have to be a physical incident of arrest, right? So that's when the incident happens. In the reconciliation phase, where we're seeing about guilt, right? Sometimes the survivor feels guilt during this phase. This is the phase where I see survivors wanting to release the charges. This is why I see survivors wanting to recant or even fund the batterers or perpetrators funds when they're in jail. This is when the perpetrator, either he apologizes or he blames the victim for what happened to them. And, oh, it wasn't as bad as it was. This is where a lot of the term gaslighting comes in. And it's basically a conversation back and forth between the survivor and the perpetrator where they're getting back into the relationship. It does not have to look like a honeymoon phase where you're getting flowers and all these things. That's why we no longer really use that term anymore. And that's why we use the phase calm. So in this phase, most likely, the abuse is forgotten, the incident is forgotten. We just move on with life like this never happened. That's what I see the most in my field, in my personal observation in the field that I work in. It's just forgotten. It didn't take place. These things happen in relationships. We move on. But like I said, it doesn't always look like, oh, you're getting flowers, you're getting presents and gifts, and it's all love. It doesn't always look like that. Sometimes it just looks like we're moving on with life.
And you kind of talk about in the incident phase, it could be verbal, emotional, or physical. Is it usually one of those three, verbal, emotional, or physical?
It could be a whole host of things. It doesn't always have to be fit into that box, because domestic violence is not a box. Every relationship looks different. Every incident looks different.
Now, in the field, is there also a concept of the power and control wheel?
Yes. The power and control wheel was created in 1980. It's a qualitative tool where 300 survivors were interviewed, and we use ground theory, which is a themes theory, to find different themes, well, similar themes, to create this wheel to show the tactics of the perpetrator.
And have you used a demonstration of that power and control wheel to explain how an abuser will exert power and control over a survivor?
Yes.
Now I'm going to show you what's been marked as State's Exhibit number 75. Do you recognize State's Exhibit number 75?
Yes.
And how do you recognize State's Exhibit 75?
It is the power and control wheel.
And would that help you today in your testimony and explain to the jury the power and control that abusers use in relationships?
Yes.
Your Honor, this time the state like limit State's Exhibit 75 for demonstrative.
This is a demonstrative exhibit?
Yes, sir.
No objection to using it as a demonstrative exhibit.
Exhibit 75 is admitted for demonstrative purposes.
Thank you, Your Honor. Looking at State's Exhibit number 75. Okay, let me remove them. If you can, and what I'll do is I'll navigate over here. Just tell me when I need to go up or down. So go down. Okay.
To show like the contributing factors and okay. Oh, that's
all right.
Mm-hmm.
Okay. So if you can explain kind of the wheel itself, and if you could, you may have to step down just because you might not be able to do on this screen. Yeah. So to explain to the jury what.
So I want to explain to you all what this wheel is, but I want to tell you why it's structured this way. So on the outside, so first, this isn't the first wheel. This wheel has evolved since 1980. And the reason why I use this wheel, because it's a very much gender neutral wheel, because we understand that domestic violence isn't just gendered from man and woman, right? It is a whole host of genders, a whole host of communities that suffer from intimate partner violence. And it's structured this way because the physical and sexual violence is seen. Those are things that can be seen, so that's why they're on the outside of the wheel. And these are systems that contribute to intimate partner violence, right? Systems, isms, and things I train about when I'm out in the community trying to help people understand how these different systems could trap someone in a relationship, right? So on the inside, we're going to start with using intimidation. On the inside, these are factors or tactics you may not see when you approach or survive of domestic violence. You may not see intimidation. Mind you, these are all inside the spokes. You may not see someone having a fight over book. You may not see someone abusing pets or using weapons as threats, right? Putting a gun on the table is not illegal. You may not see the emotional abuse. You may not see that person being put down. You may not see the humiliation, or you may not even think that that person is being humiliated or being exposed in that moment as a form of power and control. Using isolation. This is very important because this happens very early in the relationship. They isolate you to them and their support system, right? They don't want you to have any outside friends. They don't want you to have any outside family. They don't want you to have sisters, sorority sisters, or whatever is your support system. Sometimes this transfers, like this parallel to economic abuse, right? Your livelihood. So what I see a lot in isolation is survivors being pulled away from their family, right? Being moved across country, or being told that it's abnormal to speak with your family members every day, right? They're trying to reduce your access to people so that others on the outside don't see the abuse that's going on inside the home. Minimizing, right? It wasn't that bad. What are you talking about? I'm minimizing the joke. I'm minimizing what took place. Specifically on the cycle abuse, the incident. There's a minimization going on during the reconciliation phase. It wasn't that bad. You made it look like it was the end of the world and it wasn't. Using children. That is a major, major part of why a lot of survivors stay in relationships, because they want to protect their children, right? That is just the natural part of being an adult. And sometimes when there's a separation, because this abuse can continue outside of the relationship. The relationship could end, but if you have that connection with children, we can start using the children as the go-between. We can start using the children as someone else to continue the power and control and the abuse. We can also use children to harass family members, use children to indirectly affect your livelihood, right? Calling your place of employment and things of that nature. Now we use privilege. So this was changed to use. We can use the Bible, we can use someone's race, their culture. Privilege can look a lot of different ways. In economic abuse, I always talk about you must have control of all the money, you must make the most money. No, it could simply be tampering with a survivor's car so that they can't go to work, right? Ruining credit, continuously getting evicted, invasion of accounts. It could look any way, but the whole goal is to take control of your economic livelihood. Using coercion and threats, that's in the definition. I'm going to coerce you to stay in this relationship. Coercion is really used a lot in the queer community. I'm going to out you. This wheel, the healthy relationship wheel, we have so many different wheels out right now, but it is the same concept, power and control.
Thank you. And in every abusive relationship, will you see every tactic used?
No.
In order to define a relationship as an abusive relationship, does there have to be like a magic number of events or physical violence or a certain amount of times that someone uses isolation to define that this relationship is domestic violence?
No.
How do you distinguish in the field, say, an isolated incident from a relationship that would be considered a domestic violence relationship?
So to explain an isolated incident, we look back at the definition of domestic violence. The definition is a pattern of coercive behaviors to gain and maintain control. That's what it is. And if there is a pattern, it doesn't take, it's an indefinite number, right? We don't have a certain number. We don't have a certain theme for it to fit in. As long as it fits under that definition and that survivor is explaining that relationship from beginning to end or in the middle, patterns of coercive behavior to gain and maintain power and control, or for the perpetrator to exert power and control, we define that as a domestic violence relationship.
Now, is there any literature regarding the various roles an abuser can play during a domestic violence relationship?
Yes, so there is trainings and information out there about men who batter, right? But we still use that foundation for all genders. And in that training and in that information, the roles that a perpetrator will play to gain and maintain that control is the hero, the judger, or the victim. In that relationship, we see that theme continuously circling and circling to show power and control against their intimate partner.
Okay, so you said it's the hero, the judger, and the victim.
Yes.
Can you explain the hero role?
So the hero usually shows up first, right? I'm saving you from your family. I'm saving you from your friends. I'm saving you from economic depression. I'm saving you from food insecurities. I am here to be a savior, to push you forward in life, right? And there's no infinite time on how long that will last. But yes, I'm the hero. I'm here to save this family, and I'm here to save you from yourself. When we think about the judger, let's go back to the hero. I have saved you. And then as the judger, you may say, the survivor may say, oh, now I want to connect with my family again. I feel like it's time. I think forgiveness is the right answer. Then I'm going to judge you for that, right? No, why would I save you from them? Why would you go to some place where they hurt you? Why would you interact with people who harmed you? I saved you from that. So I'm judging you in that because I don't want you to go over there, right? I want to maintain that power and control. So I'm judging everything you do when it comes to seeking outside support. And then the victim is, this is a basic answer of the victim. The survivor is now, perpetrator is like the perpetrator playing the victim. The survivor says, I'm leaving the relationship. This is not healthy for me. And then we play the victim role. Like, what did I do to you? I saved you, and now you're trying to leave me. I deserve closure. I deserve these things because I am the victim here. And you're leaving me for no reason, right? You're leaving me for no reason. I did all these things for you. It exerts this level of guilt that can keep a survivor in the relationship as well.
Is it unusual for a victim of domestic violence to remain in a relationship with the abuser after the abuser physically assaults them?
It's not unusual. It's very common.
And why is it common?
So we go back to coercion, we go back to reconciliation. It wasn't that bad. You did this to me. We could make this work. Everyone has heard the term, this will never happen again, right? So it's a level of guilt that the survivor is hearing, or a level of happiness because, wow, they've told me that this won't happen again. This person is actually owning up to what they did, and now we can move forward in a relationship.
Same question. Is it unusual for a victim of domestic violence to remain after someone verbally abuses or verbally assaults them?
Yes, it is very common for someone to stay.
Is it for the same reason that you kind of just discussed?
Yes. Or even sometimes survivors blame themselves when it comes to verbal abuse or emotional abuse. Like, I deserve that. I really was acting that way.
Is it unusual for a victim of domestic violence not to pursue criminal charges in a case?
It's not unusual.
Ms. Hilton, are you done with that exhibit?
Oh, I'm sorry. Yes,
That's
Your Honor.
okay. If you could take down your screen share.
Yes. And is it unusual for a victim or for a survivor of domestic violence to withdraw or ask for a temporary protective order to be dismissed or withdrawn?
It's not unusual.
Why not?
I want to go back to the reconciliation, that when we're reconciling, right? So the survivor may believe the perpetrator has changed. This is not necessary. This is we're overdoing it, right? Yeah, I believe that this is way too much. Like, I believe that you're going to co-parent appropriately, and we don't need all these parameters. You could be coerced into that, or a survivor can say, well, we're always going to have they told me that we're always going to have a third party when exchanging children. We're always going to, this person is not going to do these things alone with me anymore. So, of course, I don't need this level of protection anymore.
And I use the term a temporary protective order. Can you define what a temporary protective order is?
So in Georgia, a temporary protective order is what the community would know as a restraining order, that you can't be within X amount of feet of me. You cannot be alone with me. You cannot be within X amount of feet. You cannot contact me indirectly or directly. You cannot use family members, friends, siblings to send messages. This is a complete stop of communication.
And in Georgia, to get a temporary protective order, is that a civil hearing? Like, are both parties present when at a civil hearing to get a temporary protective order?
Yes, so you're going to have a plaintiff and defendant, but it's a civil proceeding. It does not turn criminal until that protection order is violated. But it's a civil proceeding. It is done in front of a, depending on the county, a family court judge, or done in the protective orders office to have due process, because the defendant of that temporary protective order gets to deserve, constitutionally rights. They are able to do due process.
Now, earlier we talked about kind of isolation as it relates to the power control wheel. Hypothetically, if an abuser or perpetrator moves a victim to a location where she's unfamiliar, has no friends or family, can that be a form of isolation?
Yes.
How can that be a form of isolation?
So that can be a form of isolation because you are moving that survivor away from their support system. You are now around my family and friends, and they will be your influence at that time. So you have no immediate access to any support system when you're moved up and rooted from a place you know and are familiar with to somewhere that's new.
Hypothetically, if an abuser moves the victim to a neighborhood, or a perpetrator, moves a victim to a neighborhood for which he's familiar, he has friends, he has family in that neighborhood, he has neighbors in that neighborhood, and he never introduces his significant other to those individuals, can that be a form of isolation?
Yes.
How?
So that's a form of isolation where you are keeping the survivor in the home or away from the community so that the survivor cannot even create their own community. Right? You typically, when someone moves to a new community, you end up creating your own community, right? If you don't know anyone, you would be introduced as someone's spouse, and then typically in a healthy relationship, that spouse gets to navigate that neighborhood, join committees, or do whatever they need to do to feel comfortable.
We talked about isolation, and if an abuser, can an abuser isolate you, strike that. If an abuser isolates you from your children, can that be a form of control?
Yes.
Are there times when a perpetrator uses family members to kind of step into the place to exert power and control over a victim?
Yes.
How can that happen?
So specifically, if you're isolated to your partner's family members, they can use coercion as well. They can use the children. They can use these same tactics of emotional abuse and minimizing and threats to keep you in that abusive relationship. They're just doing it from the outside, but they can still be enablers. They can enable the perpetrator's behavior and use the same exact tactics that a perpetrator would use to keep you in that relationship.
In your experience, if a survivor is being abused and maybe her family members, his or her, family members maybe see signs of that abuse and they want to confront the abuser, and the survivor stops them from confronting the abuser. In your experience, what are some of the reasons that the survivor will not want a family member to, say, confront or approach an abuser?
Your Honor, I object to individual instances of her experience.
Sustained. You can rephrase if you'd like.
Sure. Hypothetically speaking, if a survivor does not want her family member to, his or her family member to approach or to speak with an abuser, is that a form of self-protection?
Yes.
How?
So when we think about the dynamics of domestic violence, when we have outside family members approaching the perpetrator, the survivor is going to take the brunt of the blame for that family member or friend approaching and accusing or exposing domestic violence, right? Specifically if the survivor is still living in the home. So it is a form of protection. And it also can be a form of protection for the children.
Now, as it relates to this case, what, if any, information did you have as it relates to this particular case here?
I don't have any information. As an expert, I come in blindly because I'm here to stay within the psychoeducation and the science of domestic violence.
Let me ask you this. Did you know that this was a murder case?
Yes.
Did you read any police reports as it related to this case?
No.
Did you view any temporary protective orders as it relates to this case?
No.
Did you listen to any interviews as it relates to this case?
No.
Did you interview anyone as it relates to this case?
No.
You spoke about earlier that you've been qualified as an expert in Georgia in about 47 cases. In those previous cases, have you had substantial information about those cases when you testified?
No.
Can you tell the jurors about being a kind of general expert? What's that mean?
So,
A what?
A general expert.
General expert? I don't know what that means, Your Honor.
Sure.
I guess that's why she's asking the question.
Right. Why is it that you choose to have minimal information about the case?
I have minimal information because as an expert, I am not here to diagnose domestic violence, and I'm not here to prove guilt or innocent. I am an expert. I'm a social scientist on intimate partner violence, and that's all I can offer the court.
Okay. Are you getting paid to testify today?
Yes.
How much are you being paid?
$250 per hour.
And was your testimony today based on your education experience working with domestic violence survivors?
Yes.
Court's indulgence for a moment.
Sure.
Let me ask you this. hypothetically, if a survivor gives full custody of her children to the perpetrator's mother, can that in some way be used to exert some form of power control over a perpetrator?
Your Honor,
I mean, over a survivor.
I'm sorry. I object to this kind of using evidence and posing it as a hypothetical to specifically ask her opinion of that specific conduct.
Understood. Overruled. Go ahead.
Do you need me to rephrase?
Yes.
Hypothetically, if a survivor gives full custody of her children to a perpetrator's mother, can that be used in some way to exert some form of power control over that survivor?
Yes.
How?
So if the perpetrator's parents now have the children, they have control of the children. They make choices for the children, and that leaves the survivor powerless in that situation unless the survivor navigates to comply with the current guardian's requests, the current guardian's recommendations. It could lead to an imbalance of power from that parent. So yes, that can be definitely a form of exerting power and control.
Court's indulgence.
Sure.
Careful. Thank you. No further questions.
Thank you.
Thank
Mr.
you.
Samuel, questions for this witness?
I don't want to mess up my other ankle.
Good morning. Good afternoon, Ms. James.
Good afternoon.
Not doctor yet, right?
Almost.
Almost. When will you be doctor?
May of 2026.
Excellent. You and I met only once before, right?
Yes.
A couple weeks ago. In this courtroom, right?
Yes, about a week ago.
I'm going to ask you some of the same questions as Ms. Hilton. First of all, you actually worked at the Fulton County DA's office for quite some time, right?
Yes.
How many years were you working there?
I started work in July of 2019, and I left in January of 2023.
Okay, so 4-ish years.
Yes.
Okay. And did you work with Ms. Hilton during that time?
Yes.
With Mr. Fawcett or Mr. Wilson?
No.
Okay. How many times have you worked with Ms. Hilton in a case?
So in the victim advocate role, we are assigned certain courtrooms. So I would only work with Ms. Simone if she was doing a case, if she was assigned to that courtroom or a case to that courtroom. And also she was the deputy, what we would call the deputy district attorney for the domestic violence unit. So she had minimal interaction with the bulk of the cases.
Just asking you for a number somewhere between X and Y.
I don't really, I can't really define a number.
That's not a problem. How many times have you testified as an expert in one of her cases?
I believe once.
Okay. Of the 47 times that you testified in Georgia, were they always for Fulton County?
No.
Percentage-wise?
If we're looking at a percentage, most, I would say maybe 95%.
We're Fulton County.
We're Fulton County.
Right. So 95% of 47 would be, I don't know, 45, something like that?
But also one of those cases was with the defense.
Okay. So there was only one occasion where you ever testified for the defense?
In Fulton County.
Okay. And all the other times you were testifying either for Fulton County or, I don't know, DeKalb, Gwinnett, Cobb, somewhere? Correct?
Rephrase.
Well, I was just trying to do the arithmetic, but you said 47 times. One time you testified for the defense. The other, whatever, 44 or 45 times you testified for the prosecution. And almost all in Fulton County.
Yes.
Okay. And so you're being paid now to be an expert instead of being a member of their staff and just coming in and testifying, they meaning the prosecutors. Now you went out on your own and you get to bill for your time, correct?
Yes.
Okay. And do you bill for all your time or just when you're sitting in the chair?
I bill for all my time.
Okay. So when we're late starting court in the morning and you have to sit out there, you bill $250 for that too?
Yes.
Okay. We'll have to remember that, Your Honor. Do you know how much you've been paid, how much you've billed in this case, or how much your hourly has been in this case so far?
Not yet.
Well, I know you haven't finished yet, but estimate the amount of hours you've put into preparing to testify in this case.
I would say estimated 3 or 4.
Okay. And you met with Ms. Hilton, obviously, correct?
Yes.
She reviewed the questions she was going to ask you.
Yes.
She reviewed the hypotheticals she was going to ask you.
Yes.
She told you, I'm going to ask you in particular about isolation, and she said, I'm going to ask you in particular about the family, having custody of the children, right?
Yes.
Okay. And you told her what your answers were going to be when she asked you those questions, right?
Yes.
Okay. Did she ask you any questions, I'm curious, in preparing that you said, no, I'm not going to be able to help you on that?
No.
Okay. So she would say, I'm going to ask you X and Y and Z and A and B, and you said, yeah, I can help you with all those things.
Yes.
Okay. I'm going to ask you a few different times and in a few different ways about your knowledge of the facts of this case. But before I do that, I'll probably end just like Ms. Hilton did with that. Your testimony, in essence, is an opinion based on a lot of experience in teaching and meeting with people and reading about the characteristics of abusive relationships, correct?
Yes.
Okay. You said, I wrote it down, that you can't put abusers in a box. I'm not talking about punishment, talking about, one size fits all doesn't work, does it?
Yes.
That's correct, right?
Yes.
Okay, I asked a negative. That if you looked at did you say thousands maybe, or hundreds of abusive relationships you've looked at, more than just, a little bit, they're all different, right?
Yes.
Okay. Every relationship is unique, right?
Yes.
The abusers, and I'll just say the partners, whether they're gay, or lesbian, or trans, or male-female, or whatever, they can be wealthy and still have an abusive relationship.
Yes.
They can be poor, poverty-stricken, and still have an abusive relationship.
Yes.
There can be a family of history of abuse, a family history of abuse. In other words, generation to generation, correct?
Yes.
Sometimes you'll see partners for whom both sets of parents were in fact abusive, right?
Yes.
But sometimes you'll see partners for whom the parents, there's no evidence of any history of abuse in the generation above the one that you're looking at, right?
Yes.
Some parents, again, I'm talking parents of the partners, are abusive to each other, right?
Yes.
Some parents are abusive to their children, correct?
Yes.
Including the people you look at who then become the partners in the abusive relationship.
Rephrase.
Okay, I've got two generations here. I got the generation above the partners being, however you want to characterize them, whether man, woman, or whatever, abuser and what was the other word? Driver, you said? What was you said instead of victim, we call them?
Survivors.
Survivor, and so I'm looking at the generation above. Sometimes they're abusive to each other, right?
Yes.
And both the abuser and the survivor may think of their parents and think, this is normal. This is how I was brought up in my family. And justify it in their head, correct?
Yes.
And so what I was asking then was, is it sometimes the case that the parents of either the abuser or the survivor are abusive to that person.
Yes.
So abuse isn't always just limited to same generation, if you will.
No.
You can be abusive to your children, whether your children are adults or teenagers, or you can be abusive to your grandparents, right?
Yes.
Some parents spank their children, some parents don't spank their children, right?
Yes.
We wouldn't call that abuse unless it went overboard, correct?
I can't define that in this context.
Okay, not a problem.
Yeah.
I guess some parents are guilty of crimes, right? Parents of the partners you're looking at.
Yes.
You ever had a case, or do you have any experience in a case where the partners, the alleged abuser and the alleged survivor, you know, the people you're looking at, that one of them is the child of a serial murderer?
No.
Would that be unusual?
I can't answer that in
Would
this
that
context.
fit, I'm sorry.
I can't answer that for you. I'm sorry.
Would that fit the dynamic that you're looking at, or would that be kind of outside the wheel and have to try to figure out what's going on there?
It sounds like out of the scope.
Yeah. Some people run away from home at a young age, teenagers, right?
Yes.
Some people marry at a very young age, 16, 17 years old, right?
Yes.
Okay. Some people don't. Some people get married late in life, right?
Yes.
Okay. Some people are suffering from PTSD, perhaps veterans, right?
In general, yes. It's a diagnosis.
Yeah. And PTSD can be caused by a variety of things, correct? Not just being in Afghanistan, but maybe from your upbringing, correct?
I'm hesitating to answer that because I don't practice. I don't do clinical practice in Georgia. I'm not licensed in Georgia to do clinical. I'm only licensed in Florida. That's why I'm hesitating to kind of answer that, because I don't want to be unethical in the state of Georgia when it comes to like diagnoses and mental health and a DSM-5.
Let me put you at ease a little bit. I'm not going to ask you for a diagnosis today. You're not going to be sued for malpractice for anything.
I don't want to.
Just in general, I'm not a doctor either. You know, PTSD can be the result of all kinds of different kinds of trauma, correct?
Yes.
Post-traumatic, right?
Yes.
It could be something that happened in your childhood. It could be something that happened when you were a teenager. It could be something that happened when you were in the military, right?
Yes.
All those things can create PTSD. Is PTSD something that you see in your experience being part of the dynamic, the wheel, if you will?
No.
Okay. You don't see people who are suffering from mental health problems?
So when we talk about the definition of domestic violence, we practice as it is a choice. I'm trying to make sure I stay ethical.
Yeah, sure.
We practice it as a choice, you know.
Okay.
Yeah.
I guess what I'm asking is, I apologize if my question was lousy, but either the abuser or the survivor might be suffering from mental health issues, correct?
Possibly.
Okay. If you look for the root cause of abuse, it might be, for example, infidelity.
The root cause, what we study is under the definition is exertion of power and control.
Well, that is the abuse. But the cause, if we treat it as something that's caused by something, either you and I, you're at least close to being a doctor. I'm nowhere close to being a doctor. Something causes either the person to be the abusive partner, and something causes the survivor to be susceptible to being. I'm not asking what abuse is. We'll get to that. I'm asking what causes it.
What causes is a choice. There's no diagnosis for domestic violence. There's no root causes of domestic violence. It is one individual making a choice that they believe is right to exert power and control over their partner.
Does the age and duration of the relationship have an impact on what would lead to abuse?
No.
There may be problems with alcohol.
Yes.
There may be problems with drug abuse.
Within the relationship, yes.
Huh?
Oh, within the relationship, yes.
And there may be other, as I said, mental health issues involved that you have to deal with in the relationship.
Personally, each individual, they may have their own.
Right. You don't believe, and I think you said this to Ms. Hilton, that all abusive relationships are the same either.
Yes, they're all, each one is unique.
Some may be more physically abusive, some may be more emotionally abusive.
Yes.
No expert would ever claim that all abusive relationships have the same characteristics or the same causes, correct?
Correct.
Your wheel, for example, that we had on the screen for a while. Remember this?
Yes.
This is demonstrative exhibit 75. I don't think we need to put it on the screen again, but I bet you've memorized this, haven't you?
Yes, it's one of my tools. So.
Yeah. How often have you used this in court?
Many times.
Okay. The wheel, each of the pie pieces, right? The wheel looks like a pie, kind of, right?
The spokes? Yes.
Well, you call them spokes, but I'm looking at the triangles as pieces of pie. Maybe that's because I'm thinking of food. But
sure.
And each of these pieces of pie have lists of examples of how we use, intimidation is used, how emotional abuse is used, isolation, minimizing children, privilege, economic abuse. Did Ms. Hilton review this with you and say, let's see how many of these factors we can find in our case?
No.
Have you talked to her about it before?
I spoke with her about the power and control wheel, yes.
Okay. Did she talk to you about the fact that we are not involved in this case with ruining or destroying property? Are you aware of any evidence of that in this case, either through hypothetical questions or what you were told by the DA's office?
No, I'm not aware of any of that.
Anything to do with abusing pets?
I'm not aware of any.
Anything dealing with displaying weapons?
No.
Are you aware of any weapons in this case at all?
No, I'm not aware.
Okay. Are you aware of anything involving humiliation or playing games or anything like that?
No.
Are you aware of anything involving controlling what you do and what you read? Anything like that? Huh?
No.
Yeah. Are you aware of anything about joking about abuse? Do you know anything about that, or any hypotheticals asked you about that?
No, I don't know
anything about shifting blame onto you?
No.
Anything about making you feel guilty about your kids?
No.
You know how old the kids are in this case?
No.
You know how old they are? You talked about a hypothetical of placing kids with the supposed abuser's parents as being a sign of control. How about if the kids are like 6 months old and they're placed with the man's parents?
I have no knowledge of how old the kids are in this case.
Any evidence of using a 6-month-old or a 1-year-old to relay messages?
No.
Using visitation?
No.
I'm kind of going through your wheel, but you know that, right? Any evidence of treating the person like a servant?
No.
Being the one to define gender roles?
No.
Using race, culture, religion, or citizenship against one another?
No.
Preventing anybody from getting a job?
No.
Are you aware that Ms. Wolfenbarger was working at Waffle House?
No, I don't know.
You were asked about isolation. Would you describe isolation as having an outside job, having friends, having your sister working with you? Is that isolation?
Depending on this, depending on what the domestic violence looks like. Like I said, every relationship is unique. Isolation doesn't fit in a box where it has to be one thing.
Right, but if the point of isolation is to prevent you from having, recourse to friends or communities, I think you said committees or whatever it is, you have a sister, you have a job, you have co-workers, that's not isolation, is it?
It could be for some relationships. I don't know any examples of that.
Okay.
I haven't interviewed anyone in this case.
Yeah, I mean, the problem with hypotheticals is if you add a few more facts, they get more and more confusing, right?
No.
Well, I just gave you more facts dealing with isolation. You said, well, I just don't know about that.
It wasn't confusing. I said that I haven't interviewed anyone in the case. So I just can't speak to that.
Well, I'm not asking about your experience. I'm asking about your expertise. Would you describe that as being isolation?
It all depends on the nature of the relationship. Isolation isn't just one thing. I haven't interviewed anyone, so I can't answer that question.
Okay. The cycle of abuse, which is Exhibit 79, have you heard any evidence of a breakdown in communication? This is the tension building, number one. You heard any evidence about that or any hypotheticals about that?
No.
Have you heard any evidence of blaming, threats, intimidation, number two?
No.
Number three, abuser apologizes. Any evidence of that in this case that you know of?
No.
Gives excuses, blames the victim, denies abuse, anything like that?
No.
The fourth stage, calm. Any evidence of any of that in this case?
I don't have any evidence of this case. I haven't read any police reports. I haven't interviewed anyone. I'm not here for guilt or innocent. I'm just giving the science of what these tools mean and answering the hypotheticals as I'm asked.
Would you agree with me that many people who commit the crime of murder are not involved in an abusive relationship?
I can't answer that question because I don't know. I don't know.
You are aware from your experience that many people who are in an abusive relationship don't commit murder?
Yes.
I know you say you know none of the facts in this case, but you know some by virtue of the fact of the hypotheticals that Ms. Hilton said, these are the ones I'm going to use. Do these work? Can we use these, right? So you know from her preparing you that these are going to be the facts of the case. She wouldn't be asking you about something totally irrelevant, would she?
No.
Okay. Did you tell her to change any of the hypotheticals? To make them? Okay.
No.
Fine, good enough. I think you said you have no opinion whatsoever about this case, right?
I was called to do the science. I can't diagnose domestic violence. I can't do guilt or innocent. I'm not, I'm not a prosecutor or someone of the court.
I mean, I understand that, and I appreciate it. The point is that your testimony is just general observations about the way lots of different relationships that are bad exist, right?
No.
I use too many words that aren't appropriate, right? There are abusive relationships involving power and control. Your testimony focuses on that, but you don't know anything about this case, right?
No.
Correct?
Correct.
Okay. And as Ms. Hilton said, you haven't read a single police report, right?
No.
If I It's the problem with a negative question. That's correct, right? You haven't read a police report.
No, I haven't read a police report.
All right. You know, these jurors have heard, I don't know, a dozen witnesses. You didn't hear any witnesses at all, correct?
No.
You've not talked to the detectives in this case?
No.
Or the medical examiners?
No.
Family members of the people involved?
No.
Either the defendant or Ms. Melissa Wolfenbarger, correct?
No, I'm not an investigator. No.
Right. You haven't talked to her. Have you learned anything about her parents and her family and her upbringing?
No.
Even from watching a little TV or learning a little bit about the case?
No.
No idea?
I have no idea.
Okay. All right. You haven't talked to me about this case, right?
No.
We had one brief court appearance together last week, but other than that, you and I don't know each other at all, right?
No.
Okay. Those are all the questions I had.
Ms. Hilton, anything else? Yes,
Now, Mr. Samuel asked about different parts of the cycle of abuse. Could arguing be something that occurs in the tension building phase?
Yes.
Loud arguing, could that be something in the tension building phase?
Yes.
What about dragging of hair? Could that be something that be in the physical abuse or incident part of the cycle of abuse?
Yes.
What about dragging someone up the street? Could that be a part of the incident phase of cycle of abuse?
Yes.
Okay. What about markings on necks consistent with strangulation? Could that be evidence of an incident of abuse? Could a victim or survivor who drops a TPO after a private meeting with a perpetrator be examples of what can happen in the reconciliation phase?
Yes.
Can a survivor, who after meeting with her abuser privately decides to give full custody and control over her child, something that can happen in the reconciliation phase?
Yes.
And give full custody of her child to the abuser's mother. Could that be something that happens in the reconciliation phase?
Yes.
If a survivor, after an alleged abusive incident, once she called the police, goes back to the abuser, could that be something that happens in the reconciliation phase?
Yes.
And are those some examples of what you've seen about how the cycle of abuse can occur in a domestic violence relationship?
Yes.
I have no further questions.
Thank you, Mr. Samuel.
No, thank you.
Okay. Thank you, ma'am. You may be excused. You can step down.
Thank you.
Okay, ladies and gentlemen, it's about 3:05. We're going to take an afternoon break, and probably 15 minutes, maybe 20. And we'll be back in here at 3:25. Realistically, it's going to be closer to 3:30. You know how that works. You've developed an understanding of court time now. Thank you for your understanding. We are in recess, and we'll get you back in here as quick as possible. Thank you all. You may be seated. Anything we need to put on the record regarding that witness or anything else before we adjourn?
No,
for a break.
Can you put on the record at the bench conference where I asked for a...
Yes, thank you for the reminder, Mr. Samuel. After the witness, Ms. James, was called, the parties approached, and Mr. Samuel requested a limiting instruction on the basis of 404 regarding other instances that would form the basis of hypotheticals about which Ms. James would be asked. The court, I advised you, Mr. Samuel and Ms. Hilton, that my ruling had been that those prior incidents were intrinsic, and that my understanding of the law is that intrinsic evidence is admissible for any purpose, and therefore no limiting instruction was required or appropriate. So I did not give one. Separately, though, Mr. Samuel requested that the court give a limiting instruction regarding expert testimony. Although it is not something I typically do, the state did not object. And so I indicated that I would give that instruction, which I did after the state offered Ms. James as an expert, and Mr. Samuel elected to defer his examination and voir dire of that witness and her qualifications until after the direct examination. So I instructed the jury. Any objection to the charge that I gave the jury, Ms. Hilton?
None from the state, Your Honor.
Mr. Samuel?
No objection. But I also asked for a prior difficulties instruction.
Thank you. You are correct for clarifying that. You did, in fact, ask for a prior difficulties instruction. But as I said, my understanding is that because the evidence was intrinsic, it's admissible for any purpose and is not limited for as 404B or potentially prior difficulties evidence would be.
Understood.
Anything else?
Nothing from the state, Your Honor.
Okay. We're in recess for till about 3:30. Jeffy, where did that officer go? Madam Court Reporter, are you ready? Okay, we're going to go back on the record after our afternoon break. Is the state ready?
State's ready.
Is the defense ready?
Ready, Your Honor.
Do we have our witness?
Yes. I think she's right.
Okay. Okay. I don't know what happens when people go outside. It's like they just disappear or something when they leave the courtroom. Okay, I think we're ready for the jury.
Jurors are present and counted.
Thank you all. Please be seated. State may call its next witness.
Your Honor, the state calls Dr. Carl Terry.
Come on up, please. And when you reach the witness stand, if you'll do me a favor before you have a seat, turn and face the deputy and raise your right hand. He'll swear you in, okay? Okay.
Now, when you raise your hand, please, you solemnly swear to testimony about the portion. I do. Doctor, please take a seat, state and spell your name for the record, please.
Oh, sorry. Dr. Carol, C-A-R-O-L, Terry, T-E-R-R-Y.
Dr. Terry, good afternoon.
Good afternoon.
Can you tell the court where you're currently employed?
Well, I am currently employed as the Chief Medical Examiner for Gwinnett County.
Okay. And what are your duties as a chief medical examiner?
Well, I am a forensic pathologist, and my duties involve investigating deaths that are reportable to my office under the Georgia Death Investigation Act. So these are deaths that are sudden, unexpected, unexplained, or due to non-natural causes. And as the medical examiner, my duties involve determining cause and manner of death. Cause of death is what it sounds like, what caused the person to die at this point in time. Manner of death is a way in which we categorize deaths for purposes of reporting on the death certificate.
Okay. And where did you work prior to being employed at Gwinnett County?
Prior to coming to work at Gwinnett County, I worked as an independent contractor for Dr. Gerald T. Gawitt, and that's G-O-W-I-T-T, who is the Chief Medical Examiner for DeKalb County. And not only did we handle cases for DeKalb County, but we also covered medical examiner cases for Hall, Henry, Rockdale, and White counties.
Okay. And prior to that, where did you work?
Prior to that, I worked at the Fulton County Medical Examiner's Office as an associate medical examiner.
Okay. Now, are you licensed to practice medicine in the state of Georgia?
Yes, I am.
Okay. When did you become licensed?
1992.
Can you go over for the jury your education and training?
Yes, I can. In 1986, I graduated from Emory College of Emory University in 3 years with a double major. I have a Bachelor of Arts in Religion and a Bachelor of Science in Biology. From 1986 to 1990, I attended Emory University School of Medicine, where I received my Doctor of Medicine degree.
Hang on, I'm so sorry to interrupt you. I'm just going to ask if you'd slow down a little bit.
Okay.
I want to make sure the court reporter can keep up, and you're a little bit of a fast talker.
Oh, sorry.
Thank you. That's okay. Go ahead. Please go ahead.
Thank you. So I am a medical doctor. From 1990 to 1995, I did a residency in pathology. in the Emory University affiliated hospital system. Pathology, broadly stated, is the study of disease, and my 5-year residency involved a combined program of anatomic and clinical pathology. Anatomic pathology is tissue-based pathology and involves diagnosing disease states from tissues, such as biopsies, organs, or tissues removed from living people, as well as autopsy specimens. Clinical pathology is the laboratory medicine aspect of pathology and involves such areas as chemistry, hematology, microbiology, and blood banking. During the last year of my 5-year residency, I was allowed to work exclusively at the Fulton County Medical Examiner's Office in a subspecialty of pathology, forensic pathology. And forensic pathology is the medical legal investigation of death. So, after the completion of my residency in 1995, I did an additional year of study in forensic pathology, also at the Fulton County Medical Examiner's Office, and this year of training outside of the residency was referred to as a fellowship year. And I did my fellowship year at the Fulton County Medical Examiner's Office in forensic pathology from 1995 to 1996. But because I already had a year of experience in that office, I was essentially treated like a junior attending and got to supervise other individuals in training as they rotated through the office. Following the completion of my fellowship in 1996, I stayed on staff at the Fulton County Medical Examiner's Office as an associate medical examiner. And that's where we picked up. I worked at the Fulton County Medical Examiner's Office from 1996 to 2004. 2004, I went to work for Dr. Gowett in DeKalb as an independent contractor and worked for him until the beginning of 2006. In February of 2006, I was awarded the medical examiner contract in Gwinnett County and took over doing the medical examiner duties for Gwinnett County. In Gwinnett County, the medical examiner position is not a county department, it is a contracted position. And my contract comes up for renewal every 5 years, where I have to rebid for the contract. And as I said, I was awarded that in February of 2006 and have maintained it to the current time. As we said, I'm licensed to practice medicine in the state of Georgia and have been since 1992. I am triple board certified by the American Board of Pathology in all 3 areas of pathology in which I have trained and studied: anatomic, clinical, and forensic pathology. I have personally performed between 6,800 and 6,900 autopsies. I've supervised individuals in training in approximately 700 additional cases. In my career, I have examined over 10,000 bodies because not everybody gets an autopsy. There's some bodies that I just do an external examination on and maybe draw specimens from to do additional testing, such as drug screen or other types of laboratory tests. And I have been tendered as an expert witness in the Superior Courts of Georgia over 455 times.
Your Honor, this time the state will move to tender Dr. Carl Terry as an expert in forensic pathology.
I am afraid to object, Your Honor.
Go ahead.
Now, can you tell the jury what an autopsy is?
Okay. An autopsy is a medical procedure by which a body is examined both externally or from the outside as well as internally, looking at the organs to evaluate extent of disease and or injury.
And who or what factors determine whether or not an autopsy is performed?
Well, as I said, for us as medical examiners, it's dictated by state law, which cases are reported to the medical examiner's office. And again, these are deaths that are sudden, unexpected, unexplained, or due to non-natural causes. And then once it's reported to the medical examiner's office, it is left up to the discretion of the medical examiner what type of an examination is conducted, again, with the goal to determine a cause and manner of death for purposes of reporting on the death certificate.
Okay. And the procedures that you've testified to, are they generally accepted in the medical community?
Yes.
And you tell the jury, you're familiar with Dr. Joseph Parker?
John?
John Parker, excuse me.
Yes, I am.
And who is Dr. John Parker?
Dr. Parker was a mentor of mine. He worked at the Fulton County Medical Examiner's Office and also in Bibb County as the medical examiner in that area. He was responsible for some of my training. And ultimately, when I went to DeKalb County to work for Dr. Gowett, it was because Dr. Parker had stepped down from that position. Dr. Parker, I worked with him in the Fulton County Medical Examiner's Office when I came on staff there. I think and thought the world of Dr. Parker. He passed away in 2012.
Okay. And was he the medical examiner that was, I guess, the head medical examiner that examined the remains of Melissa Wolfenbarger when they first came in?
Yes, he was the medical examiner who was on duty the day that the remains of Ms. Wolfenbarger were discovered.
Okay. And at any point, did you assist in any type of investigation or analysis as it relates to the remains of Melissa Wolfenbarger?
Yes, I did.
Okay. And what period of time were we talking about where you would have been involved in any type of analysis regarding those remains?
My first direct interaction with the remains occurred in February of 2000 when I was turning over the skull along with some other skulls to the state's forensic artist, Marla Lawson, to do some facial reconstructions. I had a case of mine from 1998 that I wanted her to do a facial reconstruction on, and she had recently completed some training. Her skills as a forensic artist were legendary in the police department, but she had adopted or had taken on some new training in doing facial reconstructions off of the skulls using clay or paper mache, and so that's when I made her acquaintance in February of 2000. She came to my office to get the skull of the case I was handling, but she said, if you have any others that you want reconstructions on, she said, I'll bring a U-Haul if I have to, give me all that you have. And she, was taking on that work, and I had amassed the reports associated with these different cases, as well as investigation summaries, and was turning them over to her. And when she looked at this particular skull, she raised the question of the sex of the skull, because it was indicated to be a white male. And Marla, if you knew her, she was very modest, even though exquisitely talented, and said, this looks like a female to me.
You're saying.
All right.
Sustained.
All right. Let me ask you this. At that time in Fulton County, were you working with investigator Tina Miller?
She was a detective with the Atlanta Police Department, yes.
Okay. Did she also assist the Fulton County Medical Examiner's Office with investigations related to missing persons and or death investigations?
Not death investigations, missing persons, and unidentified remains.
Okay. Were you aware whether or not Detective Miller went out to that location where Melissa's Wolfenbarger's remains were located at any point during the investigation?
Yes, she did.
Okay. And you familiar with the location being Avon Avenue in Atlanta, Georgia?
Yes, I am.
And is that in Fulton County?
Yes, it is.
Tell the jury what happens when, say, a body or remains come into the medical examiner's office.
Well, when the body comes into the medical examiner's office, the medical examiner on duty determines what kind of examination is going to be conducted on the remains, and then depending upon the case, that dictates what is done. Most of the time, the bodies are intact, and again, they may get what's called an external examination, just an outside viewing of the body and drawing of specimens for additional testing, or they may get an autopsy where the body is opened. And there may be a complete autopsy. In Fulton County at that time, we did not do limited dissections. We only did complete autopsies. So if an autopsy is done, it involves opening up the body and examining and removing the brain, as well as the organs of the chest and abdomen and pelvis. And in the course of the examination, specimens are collected for potential additional testing. Again, it depends upon the nature of the case.
Okay. And Any observations or conclusions, are they documented in any form during that process of performing the autopsy?
Yes, typically the examinations are documented with written notes and or dictations that are then converted into a final report.
And is there other forms of documenting the process of the autopsy itself?
Yes, also photographs are taken typically in the course of the examination.
Okay. At the conclusion of the autopsy, is there a process for reviewing or discussing observations that are made during the autopsy?
I don't know necessarily if at the conclusion of the examination, but in the Fulton County office, as we were associated with the training program through Emory, we routinely had teaching conferences and conferences where we would sit and review all of the slides that were taken, because at that point in time, things were done with 35 millimeter and slides were created. And every week we would have one or two conferences where we would go through all of the slides.
Okay. Now, in preparation for your testimony today, did you review any documents and or photographs associated with the autopsy of Melissa Wolfenbarger?
Yes, I did.
And what did you review?
Well, I reviewed, it turns out I had case notes that I had collected back at the time when I did this, when I was doing this review of the case, because I was very much interested in trying to identify remains. So I had copies of notes from the file, including some of the notes that I had made documenting some of the actions I had taken to try to get the remains identified. I also reviewed Dr. Parker's report. I reviewed any investigative reports that were in the file, as well as any photographs that were provided to me, because I did not have actual photographs from the examination.
Okay. And at any point during your work that you did associated with this case in particular, did you have an opportunity to either review any of the remains of Melissa Wolfenbarger? And if you could describe that for the jury.
Yes, I did.
And when did you do that?
Well, in February of 2000, when I was turning the skull over to Marla, that was my first time that I had an opportunity to look at the skull.
Oh, okay.
And I looked at the skull.
All right. And discuss any other opportunities that you've had to look at the remains of Melissa Wolfenbarger.
And after she was identified, I had the opportunity to go and retrieve some of the specimens that had been collected to follow up on requests made by the Atlanta Police Department's Detective Calhoun to submit specimens to the Georgia Bureau of Investigation, specifically for some drug testing.
Okay. And when you say specimens, are you referring to the extremities of remains that were located?
It was some soft tissue from the extremities, yes.
Okay. All right. Now, what, in terms of, initially, I believe your testimony that there was a process of conducting an identification. What did you do to identify the remains?
Okay. And then, too, I've also neglected to mention, also in the course of doing this, there were times when I went back to the remains, specifically the skull, to extract teeth or to take additional bone to submit for potential DNA analysis. So that was something else I also undertook with the knowledge of Dr. Parker to try to facilitate the identification. So what else I did, in addition to collecting and submitting specimens for DNA analysis, was, again, just became aware of features associated with the skull. For example, I did not need my records to refresh my memory that the skull had one filling in tooth number 31. That's something I've remembered all these years. There was one filling in that tooth. And that was something I was aware of as I was checking records and any cases came to my attention. Also, at this point in time when I was in Fulton County, I did have an interest in trying to identify unidentified remains. And I had a computer program where I took missing persons reports and locations of where people went missing and plotted them on this map along with where we had unidentified remains, trying to look and see if there's any kind of spatial relationship between where people have gone missing and where remains were found. So this is something is just about being aware of who's missing and who we have who are unidentified in our morgue. Some people have various other research interests. This was something I was very much interested in because as a forensic pathologist, one of our big goals is to answer questions. And to me, there's no bigger question than who somebody is. And that was something that was of interest to me. And so I was happy to do whatever I could to try to facilitate the identification in this case. And especially since Dr. Parker was kind of part-time with our office, so he wasn't always there. But this was something that was always on my mind.
Okay. And what was the process for identifying the skull that was retrieved in April of 1999?
Or how the skull came to be identified?
That's correct, yes.
Okay, because we had made attempts to have DNA pulled from the skull from the teeth.
Objection. Can we approach?
Sure.
And as far as the, was the Fulton County Medical Examiner's Office able to retrieve any records, dental records associated with this case itself?
Yes.
All right. Did you have an opportunity to review those records along with Dr. Hoptel?
Yes.
And was that the basis for the determination of the identification of the skull?
Yes.
Okay. All right. Now, I'm going to hand you. Your Honor, with the court's permission, I'm going to hand Dr. Terry the following exhibits. I'm going to read into the record.
Yes, sir.
Exhibits 34, 36, exhibits 40 through 49, exhibits 51 through 52, exhibit 54, exhibit 56 through 57, and exhibits 60 through 61. All right. Terry, I'm going to hand you.
Hang on just one second. Can you all come here, please? Go ahead, Mr. Fossett.
Amy, these exhibits, you could work in here to look at them.
Okay.
Okay. And after viewing those photographs, do you recognize those images as being associated with the remains of Melissa Wolfenbarger?
Yes, I do.
Do you recognize those images as being associated with the same remains that you viewed at the Fulton County Medical Examiner's Office in 2000?
Well, this doesn't specifically show the skull. Those are the remains I remember actually seeing, but I am certainly familiar with the photographs.
Okay. And are they a fair and accurate representation of what you recall observing?
Yes.
Your Honor, this time the state will move to tender into evidence. States Exhibit 34, 36, 40 through 49, 51, 52, 54, 56 through 57, and 60 through 61.
Mr. McDermott?
No objection.
Okay. They are admitted.
Now, what was your recollection of, after reviewing the documents as to when each of the skull and the extremities were located?
Well, the skull was located on April 29th of 1999, and the extremities were located June, let me double check here, I can't remember, the 2nd or 3rd, also of 1999. So let me find this. June 3rd, 1999.
Okay.
Mr. Fawcett,
Yes.
are you preparing to publish those photographs?
No, I'm not.
Okay, just
No, I'm not.
making sure we have a heads up before we do.
Absolutely, Judge. I am publishing State's Exhibit 2. So I want to turn your attention to this State's Exhibit. Is that area in itself familiar to you?
Just by virtue of the names, I don't recall ever having been out there myself.
Okay. And you recognize that as being the location where the skull and the extremities of Melissa Wolfenbarger
I
are
won't
located?
object, Your Honor. She says she doesn't have any knowledge, personal knowledge in this area.
I'm not sure that's exactly what she said, but overruled. Go ahead.
All right. You recognize that location, the street itself, as being the location where the remains, the skull, and the extremities of Melissa Wolfenbarger were located?
Yes, as I said, I'm familiar with the names, but I can't say that I directly went to that location, but I in my mind, had the skull associated with Avon Avenue.
Okay. And looking at that photograph, based on your review of your notes and your recollection, the image depicted in State's Exhibit 2, is that generally the close proximity in which the remains, extremities, and the skull are located?
Yes, that is my understanding.
I do plan on publishing photographs at this point, Judge.
Okay. So, ladies and gentlemen, I told you that I would give you a heads up so you could sort of prepare yourselves that probably the next series of photographs are going to be somewhat graphic. For those of you who are in the gallery, I encourage you, if it's not something that you want to see, to make arrangements so that you don't have to see it. Go ahead, Mr. Fawcett.
Yes. Now, Dr. Terry, you were testifying as to your, I guess, ability to review and examine the skull of Melissa Wolfenbarger?
Yes.
Okay. And I'm publishing State's Exhibit 16. And just, could you describe the state of the skull that it was in when you viewed it?
All right, in this photograph, this is a decomposing head that was in the roadway. This is the head that I saw the skull from when I mentioned that I was turning the skull over for reconstruction purposes. But again, this is a photograph I'm familiar with as it pertains to the day that the head was found in the road there at Avon Avenue on April 29th, 1999.
Okay. And after viewing the skull, were you able to determine if there was any damage to it?
Yes, there was damage to the skull.
And what type of damage are you referring to?
On the left side of the skull, there were some fractures, and there was some bone in the roadway that were described in the report, as well as in an adjacent plastic bag. It appeared that the skull had been struck by a vehicle in the roadway.
Okay. And what does post-mortem mean?
Post-mortem means after death.
And is there a distinction between injuries you would, I guess, damage to flesh or bone? Is there a difference between, I guess, pre and post-mortem?
Or ante-mortem, post-mortem, yes. Before death versus after death, yes, there's a difference.
And what is it? What differences would you observe?
Well, typically differences that you see in ante-mortem injuries, the person's alive, so they still have a blood pressure, there's blood flow, and so when an individual is injured ante-mortem or before death, you have bleeding that's associated with injury. Post-mortem or after death, there's no longer blood flow, and these injuries don't bleed.
I'm now going to show you what's been admitted at State's Exhibit 36. Can you tell the jury what we're looking at?
Okay, yes, this is one of the vertebrae that was associated with the head that was or the decomposing head that was found in the road on Avon. And this is one side of this. It's a cervical vertebra, or a bone that's from the neck area. And you can tell because, can I touch the screen?
You can. You can enable that function, and you can actually tap on it and draw on it in colors.
Okay, let's see.
There's a button. I think it's off to the left on the bottom of the screen.
Oh, okay. These structures here in this vertebra identify this as being a cervical vertebra, or a bone from the spine in the area of the neck. And as we look at surfaces here of the bone, specifically those are articular surfaces where the bone would interface with adjacent vertebrae or bone. So in looking at this surface of as well as in this area here, this is where the bone would articulate or interface with the adjacent bone of the spine. And based on the review of the report as described by Dr. Parker, this would be the third cervical vertebra, so 3 down from the base of the skull.
I'm going to show you State's Exhibit 37. I can offer no assistance with getting the marks off the screen, though.
I think there's a clear button on the maybe bottom right.
There's something that says leave.
I don't think I want you to leave.
Oh.
No, ma'am.
Nope, sorry.
I might be in distance.
Go ahead.
Yeah.
Yes.
Okay, all right. Okay, so this is the flip surface of that vertebra. And in looking at this surface here, specifically, oops. Can we bring that function back up? Okay. Specifically, these areas all appear to be kind of shaved off to the same level. And again, this is the reverse surface of that vertebra.
Now, when you are performing autopsies or working at the medical examiner's office, do you often use instruments to assist with that?
Yes, I do.
And what types of instruments do you use to, say, cut through bone or hard materials while you're working?
Typically, I use an oscillating or striker saw, where I have a blade that will either spin or go back and forth to cut through bone. Another tool that I commonly use to cut through bone are basically like loppers, kind of garden shear type things used to cut like small tree branches, and we'll use those on ribs to remove the chest plate. Typically, we'll use the striker saw or the oscillating saw to open the head and to take sections of bone.
Now, did you also, were there also photographs of Ms. Wolfenbarger's extremities included in the photographs itself?
Yes.
Right. And did those extremities have flesh on them?
Yes, they did.
Okay. And let me ask you this: do you recall, either through photographs or reports, how the condition that the remains were found in?
Yes, I mean, they exhibited decomposition and had been dismembered or cut.
What about how the remains were stored?
There were plastic bags there. For example, with the skull. There was a plastic bag nearby, but the skull was in the roadway. And then the extremities were located in plastic bags. One set of remains, my understanding, was outside of a plastic bag.
Okay. And turning your attention back to the skull, and that's Exhibit 16, can you tell the jury, was there any sign of insect activity on the skull itself?
Not that I saw in any of the photographs or that I saw described.
Okay. Republished in States Exhibit 16. And what does that tell you, the absence of insect activity, maggots, fly larvae on the skull of Melissa Wolfenbarger?
Given the condition of the skull, that it was somehow protected from insects getting to it, flies getting to it. So understanding that there was a plastic bag nearby, most likely it had been in that plastic bag soon before it wound up in the roadway, because otherwise flies would have been attracted to it.
Okay. So if this skull had been out for a day or a full day, you would expect to find insect activity?
Yes, I would expect flies to have gotten to it and have laid eggs on it.
What is the impact of it being, say, double tied in a plastic bag? What is that impact on that?
Well, again, I don't know about double tied, but at least somehow being protected from insects getting to it. That would keep flies from being able to get to the remains and deposit eggs, and which then turn into maggots.
Okay. And does the storing of the remains in a sealed compartment like a plastic bag, does that impact any determination on the timing of death, or does that impact that at all?
Yes, I mean, it makes it harder because of the fact that it is, well, first of all, you don't know where it's stored, and it's confined in a plastic bag, which is going to interfere with decomposition and things of that nature. So it's going to make it harder.
Okay. And was your indication that the image depicted on State's Exhibit 40, an image of a leg of Melissa Wolfenbarger, was your indication that that was in a protected plastic bag as well?
It would just, again, appear to be so, because, again, we don't see any insect activity exhibited by this leg. So I would say that it was somewhere where it was protected from insects getting to it.
Okay. And you testified that there was some type of, something consistent with the saw on, I guess, the neck, the vertebrae that you testified to. Is that correct?
That is correct, and that's based on my observation as well as Dr. Parker's report as well. Again, looking at those surfaces, they appear to have been cut.
And were there other extremities or parts of Melissa Wolfenbarger's remains that also appeared to have the same type of saw cutting marks on them?
Yes, there were.
Okay. I'm going to show you State's Exhibit 41. Can you tell the court what we're looking at?
State's Exhibit 41, this appears to be the right lower leg and foot.
Okay. And State's Exhibit 42. Is that the plastic bag or a photo of one of the bags that the remains were stored in?
Yes, this is a photograph of one of the plastic bags that was associated with the remains.
Is that the type of storage vessel that could prevent insects from getting access to the remains inside?
Yes, if it's secured.
Is that also the type of storage vessel that could make it difficult to determine a time, a PMI?
Correct.
Time of death?
Yeah, postmortem interval, yes.
Okay. Is that something that you typically try to make an evaluation, the PMI postmortem interval, during your autopsy evaluation?
Well, I wouldn't say specifically, but it's something we generally write down descriptions of decompositional changes that can be used to opine as to a postmortem interval.
Okay. Would the temperature outside, say the weather conditions, would that impact it?
Yes, I mean, it depends on where the remains are. I mean, where are they stored? How are they stored? Temperature is certainly a big determining factor.
Okay. What about, you testified to this, what about insect activity?
Yes, insect activity, animal activity as well.
All right. Did you see any signs of animal activity on the remains of Melissa Wolfenbarger during your evaluation?
No, I did not see any evidence of animal activity on what I had to examine or on the photographs.
And what would you observe if you'd seen evidence of animal activity?
Okay. Typically think about, like, say, dogs or carnivore type activity, chewing, gnawing on the bones, tearing of flesh, but especially with looking at the bones, looking at gnawing or scratching, and I did not see any of that indicated on the bones.
Okay. Show you what's been marked as State's Exhibit 43. Can you tell us what we're looking at?
That looks like some type of an article of clothing, maybe a sock. I don't know. It looks kind of muddy.
Okay. And State's Exhibit 46. What is that?
State's Exhibit 46 is the left foot, again showing decompositional changes and protruding out of the soft tissue. I see a segment of bone that's broken.
Okay. State's Exhibit 47. Can you tell us what we're looking at?
State's Exhibit 47. This appears to be part of an upper extremity, so upper arm and forearm.
And State's Exhibit 48.
State's Exhibit 48, again, this looks like some type of article of clothing, maybe sweatpants that are dirty and appear to be kind of breaking down or degenerating.
Okay. I'm now showing you Exhibit 51. Can you tell us what that is?
Okay, State's Exhibit 51 are the various portions of the extremities with flesh removed from some of these bones, and they're kind of placed out on the table.
Okay. And State's Exhibit 54. You know what that is?
Okay. Yes, State's Exhibit 54 is one of the bones showing a series of kind of roughly parallel disruptions of the bone, referred to as tool marks. These appear to be superficial cuts in this bone.
All right. Now, you tell the jury, is it different cutting bone with flesh on it versus cutting a bone that's been defleshed?
Yes, there is.
And what is the distinction, or what differences in those experiences have? Can you tell the jury?
Yes, it's harder to cut through bone, specifically with the types of saws that I use when there's flesh on there, because it just doesn't cut well through soft tissue or flesh. The types of saws that I typically use, the oscillating saws, are very good cutting bone, but not soft tissue.
Okay.
And it tends to catch on the soft tissue.
And when you say tends to catch, what does that mean?
The teeth tend to be somewhat fine, and the tissue gets in there, and it just kind of snags it, and again makes it hard to control, and difficult to cut.
All right. Showing you State's Exhibit 56. Can you tell the jury what that is?
Okay, State's Exhibit 56. We're looking at bones from a lower leg. The thin bone that's at the bottom of the screen is the fibula, which is the thin bone that's in the lower leg area. And you can see the superficial cuts on it. And then the bone above it that looks more irregular, that's the tibia, and it is more broken than cut.
And you say superficial cuts.
Whoops.
Are you referring to that portion in the screen depicted now?
Yes, I believe that was in the previous exhibit.
Okay. And State's Exhibit 60. Is that further example or signs of some type of mechanical device coming in contact with the bone of Melissa Wolfenbarger?
Yes, it is. That's an end of a bone that has been cut.
Okay. All right. Now, Dr. Terry, based on your review of the photographs and reports, are you able to make an independent determination as to the cause of death of Melissa Wolfenbarger?
Yes, I can.
And what was the cause of death of Melissa Wolfenbarger?
The cause of death is ruled by Dr. Parker, or my opinion?
Your opinion.
Okay, which I think are kind of subtly different. But my opinion is that the cause of death is undetermined due to dismemberment with concealment of the remains and decomposition. And actually, and also with incomplete recovery of the remains because the torso was not recovered.
All right. What can't you determine based off the things that are missing, the remains that are missing of Ms. Wolfenbarger?
I'm sorry, can you ask me that one more time?
Different way. Did you have enough? Let me ask you this: were you able to tell if Melissa Wolfenbarger was strangled?
No.
Why not?
Because of the decomposition of the remains and the lack of neck structures to examine. That makes determination of whether or not strangulation has occurred very difficult, if not impossible.
Okay. And can you determine whether or not Melissa Wolfenbarger was stabbed to death?
No, cannot.
Why not?
Again, we're missing the torso. Someone could have been stabbed or had other injuries inflicted on the torso that would have been responsible for the death, but you don't know because you don't have that part of the body to examine.
Is that the same difficulty you would have trying to determine if she was shot?
Absolutely, yes.
And is that ultimately why you're saying undetermined?
Yes, because the cause of death is undetermined here because you can't say precisely how she died. And it is confounded by the fact that you have incomplete recovery of the remains. They've also been dismembered. There's been concealment of the remains, and there's decomposition.
Okay. Now, what would you say as to the likely cause of Melissa Wolfenbarger's death?
Objection. Speculation.
She's an expert.
You want to approach for a moment?
Sure.
Fawcett, if you'll rephrase, please.
Yes. Dr. Terry, is it likely that Melissa Wolfenbarger died of natural causes?
Given the circumstances, I would say that's very unlikely that she died of natural causes.
And if you could articulate why it is your determination is unlikely that she died of natural causes.
Again, the body's dismembered. There's an attempt to conceal by placing it in plastic bags. I don't have, she was, as far as I know, she was a young female. I have no information about any significant health conditions, but even so, the fact that she's dismembered and concealed is very suspicious for some sort of non-natural death.
Okay. And when you say suspicious for some type of non-natural death, could you be more specific? Are you referring to a homicide?
Yes, I'm saying that it's very suspicious for homicidal violence, given that she's dismembered, concealed. That is very suspicious. I can't say exactly how, but it is very suspicious.
All right. And the marks, the cuts, do you have a determination as to whether they're ante or post-mortem?
Yes, I'd have an opinion that it's most likely post-mortem.
And why is that?
Well, first of all, we don't see any discoloration of flesh associated with that. Second of all, just in terms of practically speaking, it would be very hard to dismember somebody while they're alive, and especially with the marks that tightly aggregated. You'd need to have somebody incapacitated or very significantly restrained to do that. And again, this is most consistent with something that has occurred post-mortem or after death.
All right. Now, in terms of the manner in which a homicide could have occurred, if say, for instance, Melissa Wolfenbarger was strangled, would you expect to see, like I said, the presence of blood in and around the surrounding remains themselves?
No, would not.
Why is that?
Strangulation typically does not result in the liberation of blood.
Okay, and considering that possible manner of death, as well as the fact that,
I'm sorry, you said manner of death, that's a cause of death when we talk about strangulation. I'm sorry, I just want to be precise about that.
Let me ask you this. Did you, when you were doing your evaluation, did you consider the possibility that she was murdered at that location where remains were located?
I mean, that's a consideration, but I don't think it's a particularly good or valid one.
Okay, so your I guess your consideration during the autopsy was that the remains may have been placed there. She may have been murdered somewhere else.
Yes, if she were murdered, it was most likely somewhere else.
And just referencing things that could impact a timing of death or make that determination, would you have been able to tell if the remains had been, say, refrigerated?
Not necessarily, no. I mean, but again, she's been dismembered and she's in plastic bags. The remains could have been anywhere.
And if it had been, say, the remains were refrigerated, how would that have impacted a time of death determination?
That would slow down decomposition, much like if you take any meat and put it in your refrigerator. The refrigerator versus the freezer, it will slow how it degrades.
Okay. One moment, Judge.
Sure.
Your Honor, can I approach?
Sure. Okay. Thank you.
All rise for the jury.
If you would step outside for just a few minutes. Thank you. Okay. So the reason that I asked the jury to step out is that we had, at one point, Mr. McDermott had objected to what he was concerned was going to be a line of questioning by the state regarding this witness's statement as to the results of some sort of DNA. I indicated that for now we were going to stay away from that topic with this witness based on the discussions that we had at the bench. And the reason that we are now revisiting that issue is that Mr. Fawcett approached and asked the court to sort of revisit that ruling, and I felt like we needed to have a more fulsome conversation on the record on that topic so that I could rule, and so that's what we're doing now. Mr. McDermott, you were the one who originally asserted that it would be improper for the expert to for Dr. Terry to make those statements, and you were citing the Williams case, which I found. I think you also cited a Watkins case, which I was not able to locate. I mean, I found, that doesn't mean it, I mean, I just can't find it. I found Disharoon, which obviously where I think Namias is indicating that's an issue that's before the Supreme Court, but.
You said Williams, but the case I cited was Smith v. Arizona.
I apologize. I thought you said the Williams case out of the U.S. Supreme Court and the Watkins case out of the Georgia Supreme Court.
Smith v. Arizona out of the U.S. Supreme Court.
That's after Williams and explains Williams.
Thank you. That's the part I was, well, that shows you why I couldn't find the Watkins case.
Smith v. Arizona 602 U.S. 799.
602 U.S. 799. And what is the?
779.
And what is the Georgia case?
Watkins is 320 Georgia 862.
320 Georgia
862.
Thank you, sir. If you'll give me just a second to pull that up, and then Mr. Fawcett, I was going to call on you to let me know what the state's position is.
If you read Watkins, you can start at 872, paragraph head note 16. The middle of that paragraph explains it in 2 sentences. Yeah, it's, I'm sorry, 320. Georgia 862. I'm looking at around 872.
So, can you give me that site again? Because I thought you said 320 Georgia 860, but that's not.
862.
Thank you.
Yes. Your Honor, the state is relying on 24-7703. I think the issue comes down to whether or not the state is intending on introducing documents related to those test results. The experts can rely on evidence, information that is not admitted into evidence, even evidence.
And routinely do, informing their opinions.
That's correct. And so her opinion is based on it's going to be called to determine the cause of death of Ms. Wolfenbarger. And ultimately, she relied on the test results from LabCorp to make that determination as to the cause of death. And that's what her opinion is based on here.
I think maybe part of the reason I'm confused is what exactly is the DNA result that that we're talking about here?
So is
it confirming that this is Melissa Wolfenbarger or that there's some sort of DNA match to her?
Yes, confirmed. Well, the DNA match from well, actually, no, it's the swabbing of Norma Patton and the comparison of that to the extremities that were located on June 1999. Confirming that she was related to Norma Patton. Okay,
and is that in dispute?
I didn't think it was.
I mean, forgive me if I fully acknowledge I might be missing something here, but
okay.
I was not aware that there was a dispute that those body parts were in fact Melissa Wolfenbarger's. Maybe there is.
Well, first of all, it shouldn't matter whether there's a dispute or not. The rule's the rule. They can't testify to those.
Well, except that I don't have to venture into deciding what the rule is and how it applies in this case if it's not relevant evidence. That's why I'm asking the question. But yes.
There are test results in the back and forth discussion over identifying those remains that in some cases they did not match. So I don't think it is a 100% proven conclusion that all of those remains pertain to Melissa Wolfenbarger.
Okay. Well, I guess that demonstrates that I did miss something. There apparently is a dispute that all of those body parts belong to Melissa Wolfenbarger. And again, asking the obvious, Mr. Fawcett, why would whether those body parts belong to Melissa Wolfenbarger or not be evidence of the fact that that her manner of death was homicide?
I guess I'm not understanding the question.
So I don't understand the DA to be offering, I guess the evidence that you're seeking to offer that this witness would testify about is the fact that she understood from the DNA result that those were Melissa Wolfenbarger's body parts.
Correct, yes.
Some of them anyway, according to Mr. McDermott's characterization of whatever that shows. Why does that contribute to the ME's understanding of whether the death was accidental, homicidal, suicidal, or undetermined?
Well, I mean, I think she wouldn't be performing a cause of death determination if the remains weren't first determined to belong to the same person that the skull did. And I think the skull is being compared with the extremities. And that's a part of that too, because you have the same type of cuts and marks on the bones of the skull as you do for the extremities. I think that's a pretty significant fact in that determination of the cause of death being highly likely of being homicide. So I think that, you know, it wouldn't have been a comparison of the extremities with the skull if there hadn't been that information provided by LabCorp to Dr. Terry and Dr. Parker. And ultimately, that's why they made that cause of death determination after all the parts were identified and matched the parts on April 1999 and parts on June 1999. So ultimately, if there's an issue as to a specific part, the Dr. Terry could testify as to which part she swabbed and sent off. So if there's a femur versus another femur or an arm that is in dispute, I think that goes to the weight, not admissibility.
Mr. McDermott, can you, I've got Watkins pulled up, and I'm still admittedly struggling to locate the portion that you're directing me to.
Okay.
One part of the case that we were successful in.
Yeah.
Congratulations. I'd love to read it, but I can't find it.
So, first of all, that's the state case. There's also the Supreme Court case that it's Watkins is citing. But if you go to 872.
You said, I think you directed me to a head note, and I can navigate it more quickly from there.
So head note 16.
Thank you, sir.
And that'll take you to a paragraph that begins with the word second. Second, the trial court clearly and obviously erred.
I have found it now. Thank you very much.
The beginning of that paragraph says to begin the Sixth Amendment's confrontation clause. Ready? I'd like to add something from Smith v. Arizona that addresses their argument.
That's what I'm looking at now.
Well, Smith addresses Rule 703 and its relation to this analysis. If you go, well, it's in Section 2 under at Note 9, but you got to go down to the next paragraph.
Mr. Fossett, have you had a chance to look at the Watkins case or the Arizona case that Mr. McDermott is referring to?
I'm still looking at it, Judge, but we can proceed.
Okay. As I said, when we were at sidebar, Mr. McDermott mentioned the Watkins case, but I couldn't locate it while we were up here. I have now had an opportunity to review it, and it does appear that the Watkins case and the Smith versus Arizona case on which it relies would prohibit that witness from testifying. I understand your effort to distinguish it by saying, well, we're not offering the lab result itself in evidence. And I agree with you that expert witnesses do routinely rely on other people's opinions. But I think that the original ruling I made at sidebar is still the ruling, which is that the DNA test result is hearsay, and there's no one here who can testify to its to the truth of that result, or at least, well, I take that back. There might be, but this witness is not that person.
All right, Your Honor, I would ask for permission to inquire to Dr. Terry whether she collected a sample from Norman Patton, what she did with that sample, and then what she did after the sample returned. I don't think that line of questioning it touches on the results themselves. It just explains her actions and activity, and then what she did after she received information back from that person.
Mr. McDermott?
I think the rule covers that type of questioning. I mean, it's clearly designed to elicit through dancing around the issue of the statement that's being, the truth of the statement that's in the lab results. And I would say that's just as much a confrontation issue.
Okay. So as I understand it, Dr. Terry did in fact conduct a swab herself. She's certainly allowed to testify about something she undertook. She's also allowed to say that she sent it off for testing, because that's something she also did. The extent to which she received a result or anything like that, I agree, invites this sort of cutesy half dodge around the fact that there's not a DNA test result witness currently, and that DNA test result's not in evidence. And so just in generally speaking, Mr. Fawcett, the two questions you mentioned at first, I totally agree. Those are fair game. Those are actions that this person took, and she can testify about them. I think to some extent you could probably ask her what her other steps taken were in her investigation that led to her decision. But what you're going to want to be real cautious about is treading too closely to the line that invites her to say, after doing that, did you develop an understanding or whatever? Because Mr. McDermott's concern is correct that it comes too close to creating an inference that's not supported by any evidence in the trial that there was a positive DNA match.
Yes, sir. I understand.
Mr. McDermott, you can object when he asks the question if you have an objection to the particular question, if you find it objectionable in some manner, other than the record that you've already made. Anything else before we have the jury back in? Have the jury back in.
Nothing from the state.
Okay. Mr. McDermott, anything from the defense before I have the jury back?
No, Your Honor.
Okay. Can I have the witness back, please? Thank you. We'll have the jury back in. Thank you. Please be seated. Mr. Fawcett, you may resume your examination.
Yes, Judge. Now, Dr. Terry, did you ever meet with Norma Patton?
Yes, I did.
And you recall around what time period that would have been?
I think it was March 19 of 2003.
Okay. And are you familiar with the process of collecting swabs or samples from individuals?
Yes.
And can you tell the jury whether or not you did that at the time you met with Ms. Patton?
Yes, I did.
And are you familiar with collecting samples from other items that you intend to have compared?
Yes,
And did you do that in this case?
yes.
All right. And in particular, did you swab the extremities of Melissa Wolfenbarger that were located in this case?
No, the extremities were not swabbed.
Okay. What other item, a piece or body part was compared?
I'd actually have to check the record to see, but tissue from the extremities, bone or soft tissue, had been submitted for DNA.
Okay. All right. And is that the process that you use in your identifications for skulls as well as other parts as well?
It can be. Oftentimes with skulls, though, if we have dental, we will use dental to establish an identification rather than DNA.
Okay. I want to turn your attention back to some of the marks and the cutting that we were just testifying to. I'm going to show you State's Exhibit 66. Does that look like a saw to you?
Yes, that is a type of saw.
Okay. Are you familiar with the term, say, sawzall, or familiar with that term?
Yes, sawzall or reciprocating saw.
Okay. You familiar with the motion that type of saw makes?
Yes, I am.
Have you ever used one?
Yes, I have.
And the marks that you were testifying to in the bones of Melissa Wolfenbarger, is this the type of instrument that can make the type of cutting marks that you were testifying to?
It could make that type of mark, yes.
Based on your experience?
Yes, based on my experience.
That's all I have, Judge.
Thank you. Mr. McDermott, questions for this witness?
Yes, ma'am. Not many. Hello, Dr. Terry.
Hello.
You remember me?
Yes, I do.
We met just a couple of weeks ago, I believe it was, or?
Yes, we did.
Okay. And that was at your office?
That is correct.
We discussed several aspects about the case.
Yes, we did.
Okay. What methods, again, did you use to determine the identity of the skull?
The method that was used to determine the identity of the skull was dental.
And did you mention that you did x-rays?
Yes, x-rays were taken, or I had taken x-rays taken in the medical examiner's office.
Okay.
And that was to establish the dental.
And when you establish the identity through methods such as that, is it important to keep records?
Yes, it is.
Okay. And do you normally keep records when you do something like that?
Yes, records are kept in the medical examiner's office.
And did you preserve the x-rays in this case?
The x-rays should be preserved at the medical examiner's office, the Fulton County Medical Examiner's office, yes.
And are you aware that no medical or no x-rays exist in this case currently?
I'm not aware of that, but there have been changes in the regimes over the years, and at that point in time, there was the hard copy x-rays, and we kept those x-rays there. Now, I have not worked in that office since 2004, so I don't know, but they were there at the time I left the office. And now so many things are digital, but those x-rays were there at the time I left the office.
Whose responsibility was it to preserve the x-rays?
It's, like I said, they're there in the office. They were maintained in the office, so I would imagine it'd be the records custodian for the Fulton County Medical Examiner's office.
When you did the dental comparison based on the dental charts, not the x-rays, but the charts, do you remember the x-rays that were given to you to start the comparison?
Yes, there were bite wing
x-rays. I'm sorry. I said x-rays. I meant dental charts.
Oh, the dental chart. I have documented in my note that there is one page of dental charts.
Okay. And do you remember where that came from?
It came from Detective Stott, S-T-O-T, from the Henry County Police Department.
And you remember the dentist?
I do not recall the dentist.
I wouldn't expect you to know his actual name. Do you remember what date that dental record was from?
It was from 1991.
1981. Melissa would have been 13 years old at that time?
I do not recall her date of birth.
Okay. If well, do you remember observing the remains of the head? You said the first time you saw it was when?
February of 2000.
Okay.
When I was turning them over to have a reconstruction done.
So you never saw it when it was not a skull?
That is correct. I just saw pictures.
Okay, so you've only seen pictures.
Up until that point, yes.
And in those pictures, you could tell that it's badly decomposed?
Yes.
And you mentioned that there were no flies on it, so that was probably a recent...
Right, that it had recently been exposed. I didn't see any fly eggs. I didn't see any fly eggs described on it. I did not see any maggots or maggots described as being associated with these remains, even though they were described as being badly decomposed.
Okay. And you remember that the other remains are in similar condition?
That is correct.
And they had been in these bags?
Correct, with the exception of the one that was out at the time of the discovery, but a bag was nearby.
And Mr. Fawcett discussed with you the concept of PMI, post-mortem interval, is that correct?
Correct, that is what PMI
And
stands for.
that's a fancy medical examiner way of saying how long ago did this die?
Correct.
Okay. Do you remember me asking you questions about PMI when we met?
I do.
And do you remember me asking you, based on the pictures of the skull and the remains that we saw, if that could have happened in a relatively short time?
I do remember you asking that, yes.
Okay. And do you remember answering yes?
Yes, that is a possibility, yes.
Okay. Do you remember me asking you specifically, would it have been conceivable to have gotten in that condition within 30 days?
I do remember you asking that, yes.
And your answer was yeah?
Yes, that's possible, yes.
Well, you didn't say just that's possible.
Oh, okay, well.
You said enthusiastically, yeah.
Well, I mean, again, it's possible. I wasn't having the conversation transcribed, you were recording it, but yes, it is possible.
Okay.
But there are a lot of variability or variables that go into how quickly something decomposes.
Okay. And we discussed those when we met, right? That they were in bags.
Yes, we did.
Those bags could have been exposed to sunlight.
Yes, the temperature, yes.
Temperature is very important to decomposition.
It is very important to do.
And something in a black plastic bag in the sun would be warmer inside the bag than outside.
That is correct.
Okay.
I think I also mentioned we don't know where the plastic bags have been, too. They could be stored somewhere.
It's fair to say, I'm sorry, did I stop your answer?
Oh, no, I was just going to say, there's just so many variables, it's difficult to say.
Yeah, that's my point to ask. When you normally do post-mortem interval on remains that are found, it's usually an intact person.
That is correct.
And all those variables you can calculate to some accuracy how long it's been.
Yes, some of those, we can, we have some knowledge of, yes.
But when a body has been dismembered, as in this case,
dismembered, placed in plastic bags, potentially concealed,
pretty much all that calculation goes out the window.
Correct. There are just too many variables there to say what the postmortem interval is.
And I think you said to me, so it's like, could you say it's been days or weeks? Probably something like that.
Correct.
Okay.
It could be days, weeks, months. Yes.
Thanks. All the questions I have, Your Honor.
Thank you, Mr. Fawcett. Any additional questions for this witness?
Now, you were talking about the different variables. Can you say, based off of the information you have, the photographs and the circumstances, that the remains were found when Melissa Wolfenbarger died? Can you say that?
I'm sorry, can I say?
Can you estimate a time of death?
Oh, no, I cannot estimate a time of death, no.
Right. And in terms of the variables that you were speaking with, would say the tying up of the remains in a bag and dropping them off at that location, can you say that they weren't there, or that she didn't die in December, for instance, of 98? Can you say that?
No, I cannot.
And what type of variables prevent you from making that determination?
Again, she's been dismembered, placed in plastic bags. I don't know where these bags have been stored or for how long they've been at the location where they were when they were discovered. Just because they were discovered there doesn't mean that they've been stored there for a period of time. I don't know where they've been between the time of her death and when they're discovered. And I don't know when the time of her death actually occurred. So I don't know.
Okay, that's all I have, Judge.
Thank you, Mr. McDermott. Anything else?
Nothing further from the defense.
Thank you so much, Doctor. You may step down.
Thank you, Your Honor.
Counsel, can y'all approach? Knows how to whisper. And I'm including myself in that statement. Thank you, ladies and gentlemen. So it is about 5:15. We are going to adjourn for the day. I'm going to direct you a couple things just as I have each day. One, I need you to return tomorrow morning at 10:30. Tomorrow morning again, 10:30 a.m. We will begin then. And then I will just advise you, as I have each day, that your decision in this case is supposed to be made only based on the evidence that you hear in this case, in this courtroom, and not based on anything else. And so it would not be proper for you to do any independent research. Don't drive by anywhere. Don't look anything up. Don't look anybody up. It also would not be proper for you to talk to anyone about this case or to allow anyone to talk to you about this case. And that includes amongst yourselves until I instruct you to actually begin deliberating. And then the last thing, again, in case there is media about this case, I'm just instructing you to please avoid media. Don't watch the news. That way you understand that you'll be complying with your obligation to only make your decision based on the evidence you hear in the courtroom. Thank you all again for your patience and attention to this process. I will see you tomorrow at 10:30. Have a good night.
All right, for the jury.
Okay. Jury's clear. You may be seated. Any specific issues the parties want to take up before we move on to something else? So you'll remember I sent y'all the jury charges. I did want to have, I don't plan to have a full entire charge conference right now. But given that I expect that the state will probably be wrapping up its case first thing tomorrow and that we either will or won't hear, depending on what the defense decides to do, I think it makes sense for us to at least have a first pass. Have the parties had a chance to look at the jury charges that I sent and any specific matters y'all want to address in terms of concerns you have. Yes, sir, Mr. Samuel.
Yes, I looked at them.
Okay.
You want to go specific?
Any from the state? Who's going to be handling that for the state? Like, I'm sure all of you, but which one of you is going to talk about it?
I haven't looked at them yet, Your Honor.
Okay. Well, I tell you what, let me make it easier so you're not.
A couple typos.
That's why I asked you to look at them. So let me put them on the screen, and I think that will help because it will also let you understand how they will be displayed to the jury when I do the charge. So anyway, the second charge is just a general pattern charge. I mean, it's not a pattern charge. It's just a general charge of, hey, the law is what I say it is and not what the lawyers say it is. And then beyond that,
other than typographical errors, all of these are pattern charges. The only issue is to this evidence in this case, is such that you shouldn't be given or need to be tailored further.
I can give you a list of my issues. 131.42, witness supported. I'm not sure we had that.
Yeah, so again, I exercised no editorial control over this. I simply put on here what you guys had listed. So not only have we not had that, but generally speaking, attacking a witness and under 131.41 is a very specific process that sometimes may or may not have happened either. I agree with you. We certainly have not had any witness supported. I'm not even sure we've had witness attacked, except perhaps by, that one needs to be tailored because perhaps by prior convictions.
Yeah, and then
hang on. What are your thoughts in terms of witness supported, Ms. Hilton? The conversation we were just having.
Yes, Your Honor, we agree.
I mean, I haven't heard anyone be rehabilitated in that manner.
Correct. We will withdraw 131.
Okay. And to be honest, I don't know that anybody actually asked for that one. It's one of those, they go together. And if we have witness attacked in that particular way, then I'm going to keep witness supported in that way, unless somebody agrees it shouldn't be. Mr. Samuel?
I made a note of 131.80 in case anybody was wondering what we were referring to. I was referring to the immunity of Norman Patton.
Right. You made that note in, did you have a chance to file? I know you gave them to me, and at the time you gave it to me, you said you had not yet filed the jury charge request.
I served it. No, I didn't. I don't know how to file.
Well, somebody in your office certainly does, Mr. Samuel. So
yes, someone could do it. Yes.
Okay.
But everybody's got it. You know what to do about 404B and all the 1.3410. I'm perplexed. I'm beginning to think you're just not going to give any 404B instruction at all because there was no similar transaction evidence in this case.
That is, I think you're beginning to suspect correctly.
Yeah.
As I was looking at it, I had always wondered because I'd not heard what I would clearly categorize as 404B. I understand your objection and your belief that that these prior alleged, the testimony that the state has offered about prior incidents that they would characterize as abusive in support of Dr. James or Ms. James's testimony. I believe, as I said at sidebar and then said again when I declined to give a limiting instruction, I believe that those are intrinsic and that intrinsic evidence is allowable. The jury can consider it for any purpose, and so there's no basis for a limiting instruction.
Right. To be candid, I can't even figure out what the limiting instruction would be, which is kind of my whole issue, is what was it? Unless we accept your position that it's just all part of the crime, I'm not sure what the 404B instruction would even be, which is why I thought the evidence should be excluded. But we know where we've been on.
Sure, yeah, and I think you have, I think I have, after I had that discussion with y'all at sidebar, I think I actually went in and deleted those limiting instructions and the associated other crimes, wrongs, and acts instructions.
I don't want to waive my issues, but I certainly understand that they're not appropriate if, in fact, they weren't admitted as similar transactions. Okay.
Yes, sir.
I think prior difficulties, 134.20 still stays in now.
Any objection?
No objection to 134.20.
It needs some editing, but
well, yeah. I mean, if there are parentheticals still in there, that means I haven't tailored them yet. But I'm not going to waste time tailoring stuff if everybody says no, we don't need it. So
right.
Can we go back to 131.80, the immunity or leniency?
Yes.
Your Honor, the state would object to that being given. While Ms. Patton did discuss the immunity she received, that was as related to her trial with Mr.
Patton.
Mr. Carl Patton. Is not anything doing with this current case. She hasn't been given immunity. She hasn't been charged with anything in this particular case or matter before this jury. There's no pending prosecution before this jury. There's no negotiated pleas. She wasn't a co-defendant in this case, so there's no grants of immunity or leniency or similar matters as it relates to this case. So we would object to 131.80.
Mr. Samuel?
Usually I do charges sitting down, but I'll stand up.
That's fine. You're not bothering me.
Once you're given immunity, you're given immunity. It carries forward. You know, all the federal cases and all of which are the names of which are escape me now, but the New York case. Anyways, the U.S. Supreme Court said once you're granted immunity, it's good for life on that grant of immunity. So theoretically, which is all that really matters for this, she could still be prosecuted, and because the statute of limitations hasn't run, because it never does in a murder case, she could be prosecuted in theory in whatever it is, Henry County, Fayette County, wherever. And so having testified here, because she was immunized, she doesn't have to worry about that. If she hadn't been immunized, and she got on the stand here today, yesterday, whatever day it was, and said, yes, I participated in the murder of some of the people my husband killed, she could be prosecuted for it. But she can't because she's immunized.
So my concern is not quite, I think right now I sort of agree with Mr. Samuel, but not for the reason that he's outlining. It's more that my understanding of the law around it, and the pattern charge certainly, is that it's not specific, right? It doesn't say they were granted immunity in this case. And so if it's intended to be, I mean, because the factors we take into consideration when we're assessing the credibility of a witness are pretty broad. These are just examples that we give a jury in terms of things they can consider. If the state wants me to think about not giving that charge based on Mr. Samuel's request that I give it, I would say see if there's case law that talks about it being specifically designed for immunity in a case, as you outlined correctly, Ms. Hilton, that Ms. Patton was never in any jeopardy associated with this case, and I'll consider that tomorrow. Okay.
The case is Murphy versus Waterfront Commission of New York Harbor, 378 U.S. 52.
378 U.S. 52.
Yeah, and there's a long discussion of it in a Supreme Court case decided 6 weeks ago, Coleman versus the state.
K or C?
With a C. S25 A0191. Different circumstances, but it talks about how broad immunity really is. Once you've been given it, you're protected for life in every court for that testimony.
Okay. And as I said, that may go directly to my point that this pattern charge is not specific about this case. It's just about immunity generally, and if that's the case, then I will give it based on your request, but I would like some more information about that topic. So I'll take a look at this case and hear from the state tomorrow on that issue.
Your Honor, before you go, I'd just like to cite a case from Georgia, Lee versus State, 281 GA 776. And I believe the proposition is that the general credibility instruction adequately covers that.
Adequately covers the other immunity?
The other instruction.
Okay.
I need to drill down on it exactly,
Sure.
but that's what it's saying in the notes on the jury charges.
Okay.
So I'm going to look at it as well. I just wanted to give that to the court.
Thank you. I appreciate that, Mr. Wilson. Okay. Anything else, Mr. Samuel?
Yeah, a few more, but they're not big. 13430. It really just needs to get rid of all the parentheses for the defendant. No felonies of Mr. Wolfenbarger's work, but all the witnesses.
Yeah, the reason, that's why I haven't tailored it, because
At first I crossed it out, but then I realized, wait a second.
Yeah, there's lots of witnesses we've heard felony convictions about. And so if evidence comes in about felony convictions of the defendant, right, then I'm not saying it has, I'm saying if it does, then I would tailor it to be, you've heard evidence about both the defendant and a witness's criminal history. But if it's just witnesses, I'll say that.
Right. I'm a little in doubt about 13510 identification. The first page of it, I think, is fine. You got to prove that the defendant did it. That have identified him as being, but this is all about whether you can trust eyewitness identification, et cetera. Which we really didn't. I mean, it's not an issue in this case. We don't have any eyewitnesses identifying anything. So I just thought we should get rid of that and 13511. Those two pages, but leave the first one because that just says someone's got to identify the defendant as the perpetrator. It doesn't necessarily have to be in court, but.
I
believe we may agree, but if I could just have a moment.
Sure.
Tonight to.
That's fine.
Get it, but
Yeah.
we may be in agreement about that.
Okay, let me know. Like I said, I think to Mr. Samuel's point that second part, the some but not all of the factors, if you read those factors, they really do go to a stranger's identification based on eyewitness observation, and that's not really what this case is about. I'm not sure I necessarily agree with your assessment of 135.11, that would be more directly here in terms of the state's obligation to identify a defendant, but we'll go, I'll let the state have a chance to look at that and consider it and tell me tomorrow.
I crossed out my crossing out.
Okay.
That was still in.
Okay. Anything else, Mr. Samuel?
Got 2 or 3 more.
Sure.
I'm not sure about the motive instruction. I think they have to have evidence introduced of the motive. I know motive is in the malice murder instruction already. That motive is not an element, but may help you decide. But I don't feel strongly. I know it's a pattern instruction. I just don't know that there's evidence of motive that's been introduced exactly. And it seems to.
Except that the pattern says they don't have to prove motive to prove murder, and it also says any evidence of motive. If you want to argue there isn't any evidence of motive that's been offered, you can argue that, and they'll say, but yes, there has been. It doesn't matter. As I understand it, that one is written broadly enough that both sides can argue, here's our evidence of motive, even though we don't have to give it to you. And you can argue there isn't any.
There was I got a typo in causation in felony murder 21030.
Yes, sir.
But 220.23.1, which was ours, I'm not quite sure what to do about that.
I'm sorry, what is the typo?
2.20.23.1.
No, I'm sorry. What was the typo in the causation charge?
It says felony murder if you believe that they instead of he.
Thank you.
2.20.23.1. I just don't know how we're going to address this, but we need to probably think about it. Everybody needs to think about how we're going to talk about the aggravated assault that makes it aggravated.
Yeah, I full disclosure, when I was drafting these charges, realized that I've tried a number of felony murder cases. I've actually not tried a felony murder case before this one where the underlying felony wasn't also charged. I don't know, as my understanding is, it's not required to be, but I've just not had one where it wasn't also charged.
Well, they actually didn't even request ag assault in their pattern.
I understand.
Which Joel and I spent a lot of time thinking about why they didn't do that. But at any rate, we did. But now the question is, how do you do it?
Well, I think we all obviously need to have a more detailed conversation about it tomorrow after everybody's had a chance to look at it. But the aggravated assault charge I think is less confusing. The issue is deadly or offensive. I don't think that I can meaningfully charge the jury on felony murder if I don't tell them the felony is based on an underlying alleged aggravated assault. So I think I have to tell the jury, as felony murder says, the underlying felony that's alleged is whatever, and I will define it for you shortly. So I have to tell them what aggravated assault means, but that typically requires the court to explain what type of weapon did it, because that's one of the elements, is that you assaulted another person with an offensive weapon, and then you have to explain what was offensive about it.
Murder, felony murder.
And just to anticipate what we may be talking about tomorrow, it can't be strangulation because that's a separate crime, which is not alleged.
Is the aggravated assault
It's only offensive weapon, not
charged as an offensive weapon in the indictment?
Yes.
Okay.
What's the indictment?
Okay. Anything else?
Nothing. That's all I had on my list.
Okay. I'll just note, in case y'all didn't, it sounds like you would have looked at it, but I do another one that is non-pattern that I typically include. I cannot believe there's not a pattern on multi-count indictments.
but this is the one that a lot of us use, and so I include it. You'll also probably note that my charge is sort of in the order of, this is how you consider evidence, and this is, what's been presented to you and how you should think about it. Here are the elements of the crime that you're supposed to be determining if you believe occurred, and then here's how you deliberate. That's sort of the way it's broken up, and so you'll note it's not in number order, but that's sort of how I present it. And also, I sent y'all a verdict form the other day. It's pretty straightforward. It just says we find the defendant guilty or not guilty on count 1, guilty or not guilty on count 2. Any objections to that verdict form?
None from the state.
Nothing from the defense.
Okay. So I think it sounds like what I'll do is I will tailor some of the ones that it seems like we're in agreement are going to stay in based on the evidence as it currently exists. Obviously, they can be tailored again, depending on, I sometimes will tailor the defendant's choice not to testify, depending on whether he testifies or not. Although I think the pattern is written generically enough that it can stay in either way. And then obviously, depending on any additional evidence that comes in regarding criminal history, I can tailor those. Beyond that, what I'll do is wait until tomorrow, specifically so we can talk about the aggravated assault and offensive weapon charge, what we're going to do with that, and then the other ones, the other few that we've discussed.
Can you ask
the immunity charge? Yes, sir.
I'm sorry. Can you ask us about tomorrow's schedule? It's 10:30 because you have something else we need to clean up. Do you have another calendar?
Yes, I have the presiding bond calendar tomorrow morning.
So we need to clear out.
Yes, sir.
Okay.
I'm sorry.
We'll put everything in the back. And assuming our case takes a couple hours, I don't know if they have rebuttals. Do you envision going into closing argument tomorrow, or wait until Friday morning for that?
If what were to happen is that the state were to stand up and rest in the morning, and then you put on a case that is relatively straightforward and short, even assuming rebuttal, the state, we probably would be done still in the afternoon. I'm saying pushing 3 o'clock is my guess, at which point I'd rather get a final on the charge and start fresh on Friday morning with, we all agree that we've got the charge final, and so you guys get ready to do your closing, and then I think that time would be better spent tomorrow afternoon. So no, there's a very long way of answering your question, Mr. Samuel. No, I do not expect to go into closing arguments tomorrow afternoon. Anything else?
No, you're right. Nothing from the state.
May I have just a second, please?
Yes, sir.
One of my witnesses that we expected we may possibly be trying today, so I had all my witnesses come.
Yes, sir.
And one of them was supposed to come and didn't come.
Okay.
And I think she's a little bit of an adverse witness.
Yes, sir.
So I'm wondering if we could make arrangements possibly for tomorrow to have a deputy pick her up.
Is it someone, I mean, I don't have any objection to that. What are the states, are y'all aware of who this is?
Wendy Waddell.
I'm so sorry, Your Honor. We were talking about the aggravated assault.
That's okay. Mr. McDermott was saying he had a witness that was supposed to be here today who did not appear, and he thought that she might be somewhat reluctant or adverse, and he was requesting the court to see about having a deputy assist her in appearing tomorrow.
Oh. No objection from the state?
If you have an order.
I will, well, I was going to say, if I could touch base with you in the morning.
Sure.
I'll talk to her again tonight, hopefully, and we'll see where it's at.
The only thing I'll ask is if you do want me to do that, you need to have a proposed order ready for me to sign. I may need to change it, so you can just email it to me in Word format. But that way I have something done and you don't have to wait for me to write an order.
Okay.
So, okay.
Does your staff have a form order for that, or can I make one?
They probably do, but I don't have one at the ready, so.
All right.
Anything else from the defense?
Nothing from the defense.
Okay, we are adjourned until tomorrow morning at 10:30.